Judgment criminal appeal 23 of 2021.
We have a response number 6. Appellate.
Yeah. Yes.
We consider to move an urgent application
Today.
regarding
Today. What is the urgency?
it's matter of contract. Tomorrow is the date.
Matter of
Contract.
contract.
Tomorrow is the date which for opening of the financial.
So who against which department?
PWD.
You'll have to serve copies.
Yes, sir.
Advance copies.
So it's already been filed, my lord. I'll just look at it.
Subject to clearance of defect.
Take it up tomorrow, my lord.
What is the matter?
Settlement of market.
Settlement of market.
Take it down.
So item number 9, my lord. I filed an affidavit yesterday with regard to justice service, my lord. I am allowed to connect it.
Sir, mine one is deed petition. It is for listing.
You want a matter to be listed.
Yeah.
All right. Which date is convenient for you?
21st to 24th April. Any day, sir.
21st, 24th April. 23rd?
Highly-
23rd.
May I please address? Lordship, I beg to mention item number 22 of supply list. Lordship, I have filed IA yesterday. That is not on record. That may be called.
May I please, Lord.
Appellate.
I beg to mention item number 3 of today's daily list, my lord. In this case, my lord, we have filed our affidavit in opposition today, my lord, on behalf of response number 7, my lord. Petition
Again, consent.
I am appearing for a petitioner,
Petitioner,
lordship.
my lord.
Lordship, we would like to file a rejoinder in this matter.
Item 3 at joint request stands deferred to be listed after 2 weeks.
May I pray for a date, lordship? Can it be on 25th?
25th, all right, 25th April.
Obliged, my lord.
May I please, lord. Function of the other side, lord. Item number 13. That may come after 2 weeks or after a view.
Item 13 be listed. You are for the respondent.
Respondent.
Yes, any objection?
Lordship, kindly pick the date.
At the request of counsel for the respondent, Mr. D. Kolita.
Equally, lord.
That matter is deferred to be listed again on 2nd of May.
Second.
2nd of May.
Apply.
May I please, Lord? I beg to mention item number 12 of the daily list. This matter may kindly be taken up after the vacation, Lord.
Item 12 at the request of counsel for petitioner stands deferred to be listed after 3 weeks.
2 weeks,
2 weeks.
deeply obliged.
May I please, lord. Lordship, the concerned other side beg to mention item number 16, your lordship.
Yeah.
Let this matter be taken up after a view vacation, lord.
Who's for the petitioner?
Mr. Senior Counsel, TJ Mon.
I am for the petitioner, lordship.
Any objection?
No, lordship, but kindly pick the date, your lordship.
Item 16 stands deferred to be listed after
Vacation, any date, your lordship.
Lordship, 25 or 28?
25th.
Very well, lord.
20?
25th.
Obliged,
How's
lord.
that?
25th of April. The request of counsel for the respondent. Yes. Yes.
May it please your lordship, I may be allowed to move a urgent petition tomorrow, my lord. My lord, I have challenged the notice issued by which my lord stated to be field verification and my lord Panchnama.
You have filed it.
Yes, today I am filed, my lord, yet to get
Subject to clearance of defect.
my lord, my lord, very urgent, my lord.
No. Subject to clearance of
Yes,
defects.
yes.
All right.
Tomorrow.
My lord, I beg to mention in respect of item number 5, your lord. Matter may be kindly passed over for 2 weeks. Your lord.
Item 5.
5.
At the request of counsel for the petitioner stands passed over for the day.
Lordship.
Motion item 1.
My lord, on the last two occasion, I took time, my lord, to file affidavit, and they also floated new tender. So, my lord, only problem is that my instructing counsel became sick, my lord. So I could not file it.
Infractors floated new tender for the same
Same work.
work.
Same work. Same work
Became
has been floated.
infractors. You don't require instructions on that.
No, definitely not instruction, my lord. Because I paid for time to file affidavit in this case.
Affidavit.
Affidavit.
But
They filed the affidavit, affidavit in reply, my lord.
no, but a new tender has been floated. So what are you doing challenging this? If you want to challenge the new tender notice.
Then Lordship may grant that also, my lord, and as per clause 71, my lord, I have to approach the dispute resolution board.
We don't know what you have to do. What we are saying is, if the new tender is floated in place of the one which you are challenging it,
Then Lordship will give me liberty, my lord.
of course,
Lordship will give me liberty.
Mr. J. Roy, Senior Counsel, assisted by Mr. BP Sharma, and Mr. Rodikari, Learned Counsel,
For all the respondents.
for all the respondents. You are appearing as
CG.
CG. It is submitted at the bar that although a challenge was made to the, you are challenging the NIT here.
NIT.
Where is the NIT?
NIT, my lord.
You are challenging the NIT or the termination?
Termination. That is annexure, my lord.
You are challenging the termination.
Termination, my lord.
Then has it been, then perhaps it may not be infractuous.
Only thing, my lord, we have floated tender, my lord. It's at the stage of finalization.
You have floated a tender for the balance work.
Balance work. My lord, he could
But
only
he is
complete.
questioning the legality of his termination.
But my lord, there is condition 71 in the agreement which my lawyer just pointed out. Before invoking my lord, condition 70, that is regarding
That is on the merits.
arbitration, my lord. But construction, my lord, is a construction of garage in a military station, my lord. So, my lord, that's the difficulty.
No. You said that a new tender has been floated.
Yes.
This court is given to understand that this challenge made in this writ petition is to the tender.
No, my lord.
That
Only
is why
that
we thought it
termination
has
order.
become infractuous.
Yes, 21/11/2021 has been put to challenge by them.
So you are questioning the termination.
My lord, page 107.
Then what do you want? Do you want to file your affidavit?
Reply and Lordship will fix up the meeting, my lord.
Counsel for the petitioner?
But only my lord, I found objection, my lord. But the Lordship may just observe, my lord, pendency should not be barred for us to finalize the contract because, my lord,
Which contract?
the contract which we are-
Is there a stay?
Yes, no, there's one, my lord, observation in the order dated.
No. Is there a stay?
No, I think stay, my lord.
Then why?
But can they come to order dated 8, my lord?
8?
No, I'm sorry, my lord. 21/1/2024.
24.
Yes, 25. There is an order, my lord. Sorry, my lord. 8/1/2025. No, 10 to 2025. 10 to 2025. Subject to participation, my lord. He has not participated, my lord.
No, there is no 10 to, there is 11 to.
11 to, my lord.
Huh?
11 to.
11.
Yeah.
How this order has obstructed you for filing a new, going for a new tender?
But we have already, my lord, quoted the tender.
So why do you want an observation?
But observation is required because, my lord, there is one observation there in the order that the tender process shall not be finalized. My lord. The tender process is at the stage of finalization, subject to participation of the petitioner.
Not in this
There
order.
is no stay order, my lord. No, that is there, my lord.
In 11.2. Read the order.
I think, my lord, I have put it the wrong date. But there is an order, my lord, by Justice Zamir, my lord.
Not there.
Is there?
The one order of 23-1 is there,
Yes.
where it says that finalization of the tender
Yes, my lord.
would take more than months,
Yes.
subject to participation of the
Yes,
petitioner.
but what is happening in this case? My lord? 21/11/2024, the contract was terminated. From 22nd of November till 17th of December 2024, where we should have several letters to him, my lord, asking him to come
We
for
are,
ascertainment of what.
we are not on the merits of this case
Yes,
at,
my lord.
at present.
But
because
this order, my lord, is creating some trouble for us.
no, how does it create in trouble?
Participation,
No, it says
petitioner.
he's recording your submission that
Yes.
finalization of the tender would take more than 2 months,
Yes, my lord.
subject to the participation of the petitioner.
Yes, but he's not participating because he
And they
did
will-
not participate from 22nd of November to 17th of December. He didn't participate, madam. Thereafter, madam, we issued the tender.
You
Yes, madam.
did not participate.
No,
Third, whether the party. Roy waits for 2 weeks time.
2 weeks.
File reply affidavit.
Reply.
Reply affidavit. The affidavit, right. The internal CTC, on the other hand, submit that the new fresh tender has been floated and the petitioner did not participate in the same tender, and the authorities may be permitted to proceed with the fresh tender process, calling for bids for completion of the balance work,
Right.
which was not completed by them. So, there are, this writ petition, the challenge made is to the termination of the contract awarded to the petitioner. Stop. There is no interim order passed, and in the meanwhile, fresh tender has already been completed. Needless to say, in the absence of any interim order, the respondents may proceed with the fresh tender as per provision.
all right.
28, my lord.
This again on 28, and it is agreed to by the
Appellate.
All right.
That has not yet come, but after some time.
What is the matter?
My lord, I have a,
Is there any urgency? Have
Yes,
you
yes,
come to
yes.
vacancy?
They have the urgency, we do not.
we have the urgency, my lord. Urgency in the sense, my lord, my restaurant and an adjacent residence behind the restaurant, my lord, is being shut down by the police without any authority of
Have
law.
you received a copy of the affidavit?
Yes, yes, I have received.
Well,
it.
Is there any need for you to file reply or anything?
My lord, the facts will say, the affidavit itself will say that this is a concocted one. I can show it from the record, my lord.
All right, then let the affidavit be connected. Call it after some time.
Got
No,
it, got it.
Item 4.
My lord, this was a case where I prayed for shifting of my license from place A to place B. The reason for my shifting such prayer was that I was operating under a tenanted premises, and my landlord had expressed written displeasure that it cannot be continued, and so I had approached. May I invite my lord's attention to
What instructions have come?
Okay, there were certain complaints regarding shifting of this premises of this petitioner to a new location. Certain complaints were received by the TC owner. That's why the shifting has not been permitted yet.
The owner has asked you to vacate the premise.
owner had asked me to vacate the premises. Thereafter, I had approached the authorities, paid the application fee following the rules. They did all the formalities required. Eventually, up to the commissioner level, the approval was granted. Now they don't let me operate the shop. In facts and law,
the three things required. If I may invite my lord's attention to Rule 294A for a moment. I understand, my lord, from 7th of April 2025, there has been an amendment of 294, but that would not even cover my case. May I read 294A for a moment? The shifting
Of the rules of the
of the rules of the 16
294.
A. The shifting of premises, license for wholesale and retail vendor foreign liquor, country spirit, and heritage alcoholic beverages from one location to another within the same district shall be allowed by the excise commissioner or the district collector, as the case may be, with prior approval of the state government. No interdistrict shifting of any licensed premises shall be allowed. 294A1, I satisfy the requirement, the precondition. 2. The shifting of licensed premises shall be subject to fulfillment of the following conditions, namely: A. The Gaon Panchayat, municipality or town committee, municipal corporation concerned, in whose area the premises licensed for wholesale or retail vend is proposed to be shifted, has given and no objection to that effect. By the record given by Borbury Gaon Panchayat, and this is not my statement, the authorities say so. B. That the proposed premises are free from
You are trying
distance
to show that there is no precondition of
against me.
that certain objections being raised by the local
Well, I'll come to that.
person is not
There-
a ground for rejecting it.
Absolutely. Page 25 of my writ petition is of 30th of November 2024. The dates would be crucial, my lord. Page 25. The requirements of 294A are instructions reflected in page 25. May I read? This is by the Inspector of Excise, Tinsukia Sadar, and addressed to Superintendent of Excise. Madam, with reference to the subject cited above, I have the honor to inform you that I have visited the proposed site of Srimati Suspita Soikia, IMFL off licensee, who intends to shift a licensed premises from its existing site situated at Ward number 10, GNB Road, Tinsukia, to a new site at Gelapukuri Road, Katujan Gaon, Tinsukia, covered under DAG number 158 and PP number 15 at the rented premises of Sri Mausetung Borua, son of late Johar Borua, resident of Galapukuri Road, Tinsukia. The calculated distance of the proposed site is more than 700 meters approximately from the national highway. Similarly, Susmita Saikia IMFL off licensee bearing license number 60 of 98 and Country Spirit Retail off license number 46 of 1718 has already deposited the application fee of rupees 2 lakhs by Treasury Chalan number so and so, e-Chalan dated 21/11/2024. During inquiry, it is affirmed that the above mentioned licensee is in need of shifting her license from the present location as the landlord is not willing to renew the tenancy agreement.
Yes.
May I continue? As per Assam Excise Rule 16, there is a provision for shifting of licensed premises from one place to another location under Rule 294A2C2. I have personally visited the proposed site of Srimati Suspita Saikia IMFL off licensee and found that the area covered of the proposed site measuring 336 square feet and so on the ground floor of RCC building situated at Galapukuri Road, Katujan Gaon, standing on the land covered by DAG number 158 included in PP number 15. In this regard, above mentioned licensee has submitted a copy of the license of IMFL Country and Country Spirit, copy of last year renewal challan, copy of rent agreement of the proposed site, copy of Jamabandi, an up-to-date land revenue receipt, and site plan of proposed site duly signed by junior engineer of Tinsukia Development Authority, copy of NOC from Borbury Gaon Panchayat, NOC from local people, copy of existing trade license, copy of electricity bill of new premises, etc. There is no any educational institution, public place of worship, or hospital within distance of 150 meters radius from the proposed site. Hence, as per Rule 294A2C2 of the Assam Act Cycle 16, the shifting of proposal of Srimati Susmita Saikia IMF and off licensee from existing site to a new site may be recommended if authority pleases.
Who is supposed to pass the order?
That is by the commissioner that comes.
Commissioner of Excise.
Excise, block. That is page 28. That is again on the 9th of January 25. My lord, in the liquor, in whatever, we have to pay a year, financial year prior. So up to 31st March 2025, I had paid in April, I mean, the year earlier. So clearance was done. And after March, I have also paid Avenex. Now 9th January 2025, may I read, this is by the Commissioner of Excise, Assam, to the District Commissioner, Tinsukia. Sir, with reference to the above, I have the honor to convey herewith approval for shifting of licensed premises of Srimati Susmita Saikia, IMFL off licensee, District Tinsukia, from its existing site from GNB Road, Ward number 10, Tinsukia, to a new site at Galapukuri Road, Kasujan Gaon, Rangagora, Moza, District Tinsukia, in the rented premises of Sri Mausatong Borua, son of place Johar Borua, covered by Dag number 158, Patta number 15 of under Borguri Gaon Panchayat as per Rule 294 of the Assam Act Cycle 16 as amended and subject to clearance of all outstanding liabilities, if any, against the licensee. I make a statement, my lord. 24-25 all cleared, 25-26 also all cleared. So they have no reason to take a cue saying that some objections are there. I can understand while I'm in operation.
Why after the commissioner has issued
Absolutely.
an order,
Exactly, Your
another
Lordship. There,
inquiry?
after approval, this objection will receive. But there is an amendment to this excise rule, Your Lordship. If I may place this amendment rule, which was done recently, Your Lordship.
That, my lord, is 7th of April 25. Would not affect my case.
Since objections are being received, amendment of Rule 295, Your Lordship. Comes to page number 1161. If I may read, Your Lordship.
This is amended.
Amended. If I may read
This
the
is from
amendment, Your
7th of April 25. My thing comes of 9th of January 25, my lord. They had
Since-
given all approval
since
after
that
considering
we have-
all the
They
documents.
have, but their final order is not here.
So
Yeah.
final order is there. What I'm on is that page 28. It is that
So what stopped you from shifting? In view
we
of
have
the-
shifted. They're not allowing me to open it. That's my
Because-
problem.
Because of the objection, Lordship, they have received, and therefore the amendment in 295 clearly says, if I may
Have
read
you
the-
recall this order?
Lordship.
28.
No, we don't. The 295 clearly says, may I read the 295, Your
No,
Lordship?
you read 295 is okay, but this amendment came in April.
7th April.
But till now, the final order has not been issued. Shifting of this has not been approved. Though the
What is
commissioner has
page-
given approved,
What is page 28?
commissioners asked the district commissioner, I have to
The approval
convey
is
approval for
communicated.
shifting. Thereafter,
Approval
the
for
dis-
shifting of license.
Subject to clearance of all outstanding.
We have
have
because
cleared all outstanding.
we have cleared.
Though we have cleared also.
So there's nothing more to
The
do.
DC is holding the file, Your Lordship. May I say one thing, Your Lordship? 295, what the amendment says, Your Lordship. On
No,
receipt of
you
an
are
application-
representing whom? The excise or the DC?
Lordship,
Who are you representing?
I'm the excise department, Lordship.
Excise. So
Excise.
you have given an approval.
They cannot argue against.
We have given the approval, Your Lordship.
That-
But may I read for the moment?
Have you recalled this order?
Because we cannot recall this order because the first he has the approval already given has cleared all assembly. Then after the approval, the objections were received by the DC.
So what happens to this approval? You want us to set aside?
No, Your Lordship. That's why I may take a Lordship 295 for once, Your Lordship. This amendment rule,
295, all right. Pre or post?
295.
Pre-amended or post-amendment?
This is amended on 7th April 2025
After amendment?
after amendment.
Yes.
It says that on receipt of an application for grant of new license or for shifting of any existing license premises, the district collector shall send an extract of such application to the local bodies referred in subclause 1 and 2 above, and also shall also cause to display a notice at the site of the proposed premises, and shall invite such bodies or persons who desire to make objection in respect of site or location of the proposed premises to file written objection containing the ground of such objection within 15 days or date of the notice. District collector then shall cause a local inquiry on the objection, if any, and shall dispose of objection after giving opportunity of hearing to all the parties involved. If within 15 days of sending such extracts as provided above, no communication received by district collector, it shall be presumed that there is no objection to the proposed site.
So who is supposed to take the action?
The district collector has to take the action, my lord. He has to given the we have
Who
given
is
the
for the
approval of
district
shifting.
collector?
District collector, lord.
Who
District
is for
commissioner.
the district collector?
District commissioner, your lordship.
Who appears for the district commissioner?
I haven't received instruction. My landed friend, whatever is.
Why are you defending the district commissioner when you are not
Absolutely.
representing?
We're not defending your lordship, the district commissioner, lordship. The thing is that since the approval
This is an interpretation given by you
yes, the lordship.
that in view of these objections, no order can be passed. That is what you are saying.
Yes, the lordship. Since
Well,
objections
you
are
already passed your order.
the excise commissioner has given approval.
Then
The district commissioner has yet to take a call on the shifting.
you don't represent the district commissioner. Why are you holding his brief for him? The district commissioner is supposed to operate at the instructions of the excise commissioner.
Since the district commissioner as a district collector and excise department, lord.
But you don't represent him.
Under
That
the-
is what we are asking you. You have already passed an order approval.
We have
Now
already
you are
passed
saying
approval.
that the district commissioner has to pass an order with direct district commissioner. What are you doing, district commissioner?
My lord, we have written letter, my lord, but we haven't received instruction yet.
Now, there's one thing, if I may submit with all humility, my lord. All objections, whatever people would have problem, prior to issuance of the approval, all requirements were made, and approval cannot be given. This amendment
Right.
is
So
not
let us
retrospective.
hear what the district commissioner has to say
He may say,
according to the excise
no,
commissioner.
I'm not against them. Whatever they say, they may put on record.
Right.
But kindly see, we pay huge amounts. From 9th of January onwards, I am not being able to operate.
Pay huge
And now
amounts.
I've paid for this year also. Lordship may kindly see. The current year also I've paid. That page 29 onwards. 29 2 lakhs, 30 20,000, and 31 that is 3
You'll
lakhs.
have to wait till 21st.
Absolutely, I'll wait.
You get your instructions.
My lord,
You'll have it on immediately.
On the amendment part, my submission may be recorded. It is not retrospective in operation 7th April.
Let you argue once
They are arguing what today.
he is representing the excise commissioner. Excise commissioner has already given the approval. Where is the scope to argue that the rules will not apply prospectively, retrospectively? He says it is the district commissioner who has to now pass an
But
order.
unfortunately, excise department
District
is not able.
commissioner, council representing district commissioner says, I have no instruction. Now, are we to decide this matter of whether retrospective, prospective today without finding out what is the status of the district commissioner?
Or should we fix a date?
List on 21st. No, because I don't think the offices are closed for 1 week.
instruction.
Instructors get it.
But
21st.
I will say 23rd, but if our lordship, fix
23rd?
it
All right.
My-
List on 23rd April. Enabling the learned government advocate, you would ask to update instruction. From the district commissioner, Tinsukia,
Sir.
as to the status of any order passed in respect of the proposal seeking shifting of the IMFL
And retail.
off
All of.
shop of the writ petitioner to the new location.
IMFL off and CS retail off.
IMFL off and CS retail off.
Retail off. After approval.
Is taken on 23rd. The government advocate will apprise the court on the steps taken by the department, pass orders in pursuance to the order dated 9/1
9-1. Page 20.
passed by the
Commissioner of Excise.
Commissioner of Excise. This report.
The interim protection may continue.
Interim protection, interim order passed 30 with the next date of this.
Obliged.
Grateful. Photocopy ko.
May it please the Lordship. My Lord, the challenge here is made to minutes of the scrutiny committee meeting, my Lord, whereby my bid was rejected on the ground of distance criteria, my Lord. If my Lord takes up that minutes at page 57, annexure 2. This is the location,
Seven.
serial number 8910, page 57. This is the location, TSK 3, Sunpura, 3 bidders, all of them rejected. I am in the middle one, Vishal Saha, rejected due to distance criteria. This is on 1 April 2025. My Lord, now my Lord may come to my bid document where I have annexed the location, which shows the distance actually. At page 24, the site map I have prepared. Page 24. There are 2 things to consider herein. Page 24, there is a place of public worship. Place of public worship, as my Lord put it.
Page number
24. There is a place of public worship marked as A, 500 meters. That is a Namghar, registered Namghar. That is admitted fact. And there's an education institute, 800 meters. Now, my Lord, the rules 289 say that, number 1, there has to be, if there is no objection from anyone in the neighborhood. Secondly, in case of area under Gao Panchayat, it has to be 150 meters from either of these 2 places. As per the map, as well as around 100 meters from the state highway, national highway, which is also apparent from the site plan. Now, my Lord, what happened was that the circle officer went there, visited, and took a measurement from a Hari Kirtan Mandali, a dilapidated premises, stating that it was 106 meters from my shop. That, my Lord, the picture I've annexed at page 60, annexure 5.
Now it has been settled with somebody.
Nobody it says been settled, my Lord. I am only on the my eligibility. Notice may go at present.
Alright.
My only interim protection I'm praying for is that they should not retender without the leave of this honorable court.
Here, heard Mr.
And
N.K. Barua, the Commissioner, Mr. R.R. Gogoi, standing outside.
Excise Department. Response number 1, 2, 4, 5,
1, 2, 4,
1,
and 5.
2, 4, and 5.
1, 2, 4, and 5. Who is the district commissioner of excise?
The additional district commissioner, district commissioner of excise is a DC, Your Lordship. That's
DC.
so 3
Yeah.
and 6 would be
District commissioner of excise is the DC.
ex officio.
मला DC copy আমার দিয়া নাই
Hello, because there is no clarity on that. There is a district commissioner excise,
Yes,
but
yes.
by ex officio or
Yes,
what
yes.
because the circle officer is there.
There is a district commissioner.
The government can
Excise,
There's-
I haven't come across
There's
this
a
type of-
commissioner of excise is there.
Well,
There's-
ADC are allotted with excise, fishery, revenue.
Malatan, 6
You
they can
appear for all. MS, you
Mala-
ask for respondent 6.
Number
6. Circle
Six.
officer.
Lord.
Mr. Gupwe for all the respondents. Petitioner is agreed with the rejection of the bid for establishing
you are here.
a rejection of the bid response to an IT for operating an IMFL. What is their IMFL of?
off.
In which area?
TSK 3 Sunpura.
TSK 3 Sunpura. Page number
57, it is reflected there.
57. TSK 3 Sunpura. Due to the condition reflected in the minutes of the scrutiny meeting held on 1/4/2025, insofar as the petitioner concerned is that the bid is rejected due to distance criteria. Learned counsel for the petitioner submit that it is the department had detected his bid on the on purportedly on the ground that is it is within what meters out? What is that?
106 meter of a Hari Kirtan Mandali.
Where do you find it?
My lord, that is not reflected anywhere, but
Okay.
that was happened on.
As per counsel for the petitioner submit as per instructed that is the bid of the petitioner was detected on the ground that it is in proximity to Hari Kirtan Mandali.
Mandali.
Within both Hari Kirtan Mandali. He therefore submit that this does not appear to be correct view, and the distance, if any, the location of the proposed site in which the petitioner intended to open his IMFL shop subject to being shortlisted by the authority is well within the permitted parameters under the excise law, excise act and the agree with the presentation. It's further submitted that a representation, you filed some representation.
Yes, my lord. That is at the last page, page 61.
Before the district commissioner of excise, which the same is pending. Mr. R. Gogoi, standing counsel excise department, submits that he would like to complete his matter, and also MSR hearing out state government. Let the matter be fixed again on 25th of April.
Very well.
Meanwhile, insofar as
TSK 3 Sunpura.
the locality TSK 3 Sunpura, TSK 3 Sunpura is concerned, the department will not initiate fresh tender without leave of the court till the next 8 weeks.
No pledge.
It's not predicted.
Public.
Instructions were short form.
Instruction. What is it? Tell us.
Yes, my lord. And no such appeal has been filed, my lord.
My lord, number was given in the office. That's why I mentioned paragraph 8, my lord.
No such appeal filed. The clear instruction, no such appeal has been received.
Yes, my lord.
What happened, my lord? Then we can file again because on the date of filing, we went there and they
You
gave us a
give
number.
you give us the material to show that the by which number order appeal has been filed when it was
Paragraph 8
received.
we have mentioned, my lord.
Where?
Paragraph 8, my lord.
As per Brega, my lord, they have filed on 22/7/2024, my lord. And license was cancelled on 27/12/2023, my lord. More than 6 months later, they have filed this.
Yes,
You
my
may
lord.
have filed, but it was perhaps not accepted.
Yes.
Maybe, my lord. On that
It
day,
has to be-
they give us this number, my lord. When
Because
the
that
appellant-
is why, my lord, I think, my lord, they have filed this application, well, because it was not filed within the period of limitation, my lord. In fact, my lord, no such appeal was filed, my
No, my
lord.
lord, we have
That is why they have mentioned.
no, my lord. In our appeal, we have given the reason of delay also. It was not a case. We have not given it. Or we can, my lord, we can file a phrase. If they are saying that they have not received it, we can file a phrase. But fact remains that, my lord, they
You
have
have to
given
give
number.
us. You have to give us
Yes, my lord.
the number, etc. Where have you quoted the number?
Paragraph 8, my lord.
No number, but in
Paragraph
your
8,
appeal, in
my
your
lord.
appeal, where is the number reflected?
My lord, in the appeal, there is no number, my lord. They received this copy.
Where is that receipt?
They get the number. They said, my lord, when the appellant went there, they said, my lord, your appeal has been accepted. We are accepting your appeal, and this is your serial number for future reference. She noted out a number. She came back, my lord, with this number.
Even, my lord, appeal is not dated, my lord. No
So
date
that
is mentioned,
you
no
get
signature.
instructions about the serial number. Come to paragraph 8, page number 9.
Yes, my lord.
There is a serial number. Appeal is shown to be registered in this. You get the details of the registration of this particular number.
Yes, my lord, they are saying there are no such
Let them say so in the, have they said it?
No, man. Notice, let him file a case, my lord. They refiled, my lord. They charged in the office, my lord.
Is there any limitation of filing an appeal?
Limitation was there, my lord. We have given explanation also because
Then if we direct them to file, then we'll have to, you cannot object on limitation.
Yes, my lord. Let him file, my lord. They will consider, my lord. Subject to, my lord, period of limitation also, my lord, because it was cancelled on 27/12/2023, my lord.
All right, then you get your proper instructions. Your instructions will have to be listed again on 25th of April. Mr. M.
No, my
Session.
lord. Let him file a case, my lord. Then we will consider, my lord. On May.
Is there any limitation?
Yes,
Yes or no?
if he mentioned the limitation down in the appeal, my lord, that along with the all will be considered, my lord.
30 days limitation is there, my lord.
What is the provision?
233, my lord.
233.
233, my lord. Section 233.
Days.
30 days.
If we direct him to file an appeal, then he, let
No,
us
my lord.
say he explains his limitation.
Even, my lord, if this is license granted under 233, my lord, 233 is not regarding, my lord, this state license, my lord. That is also not clear, my lord.
My lord, trade license, your lordship will find it page, my lord.
License under 230.
Page 17 is the
230,
license.
my lord.
Page 17 is the
Cinemas,
license, my lord.
dramatic performance and circus, etc.
Then where is the appellate forum?
My lord, kindly see page 17 is the trade license under which they have issued, my lord. Page 17, my lord. The issued is under section 228, 229, 230. They are saying, my lord.
What is it that you are running?
My lord, temp, my lord.
Huh?
Scrap temp. Scrap materials I used to sell, my lord.
I think it is under 229.
My lord.
229.
But section says, my lord, appeal under section 230 and 231. But let him file a, my lord, case appeal, my lord. They will consider everything.
See, we have no difficulty in the petitioner on his own filing an appeal. But if we direct the respondent to consider the appeal, then it must be as per provision of law. Either you say that it should be filed under such and such provision. You are pointing out that 230 is not the provision for an appeal. 233.
Yes, because it is appeal under section only 230 and 231.
So that would mean that any license given under 229, there is no appeal forum. Then we'll have to examine the matter and pass an order. Can there be a provision that in case of any grievances, there will be no forum for a citizen to go and urge?
When, my lord, appeal is not, in that case, my lord, notice maybe issued, my lord, I will file because as per instruction, no such appeal has been filed, my lord. In that case, my lord, notice may be issued, my lord. will file my lord reply.
All right, third Learned Counsel for parties issue notice returnable 2 weeks. Mr. Setia appears for the respondent authority. 12345. Instructions received by Mr. Setia terms of the liberty granted earlier reveals that no appeal has been prepared by the petition as contended in para 8 of the writ petition. So, counsel for the petitioner on the other end reiterates his submission that an appeal has been filed and the appeal was registered as per the number reflected in para 8 of the writ petition. So, let the government advocate complete his instructions and file necessary counter if to advise within the next returnable date.
Yes, sir. This may be issued on respondent number 5.
Who is respondent 5?
Respondent number 4, my lord. Tinsukia municipal board, my lord.
So who gave you instructions here? Additional
Deputy
district
Commissioner.
notice also on Mr. Setia appears for 1, 2, and 3.
1, 2, and 3, my lord.
So it represents 1, 2, and 3 notices are waived. Extra copies be furnished within a period of 1 week from today. Steps to respond 4 and 5 by registered post AP as well as usual within a week from.
Then my interim payment position on next returnable date, my lord.
Prayer for interim to be considered on the next returnable date.
Deeply obliged, my lord.
With visual office, people lost the melody contractor melody. It comes have a NIT dated melody 22/1/2025 melody. The petitioner can come to page 16 melody. It's the NIT method.
16, 1, 6.
1/6 method. This is the NIT melody. The NIT was issued for widening and extending of road from NS 31 near Panikuti High School to BTC method. In this package melody, this work melody, petitioner had offered this beat melody.
Yes.
Now, my lord, kindly come to page 117, my lord. After submitting after being qualified in the technical bid evaluation, my lord, the POQ summary finance bid was open, my lord. Kindly come to page 117, my lord.
117.
My lord. The POQ summary was prepared, my lord. Here, my lord. The petitioner was placed as L1 bidder, my lord. Serial number 1.
Yes.
L1 bidder, my lord. Here, my lord. Although, my lord, the petitioner finance bid was qualified, my lord, here in this case, my lord, and he has placed as L1 bidder, my lord. The work was allotted, my lord, to the serial number 3, my lord, Milal Jyoti Das, my lord. Kindly come to page 118, my lord. It is a issue of notice to proceed with the work, my lord, to Milal Jyoti Das, my lord. In fact, he was L2 bidder, my lord, and it was issued on 12/3/2025, my lord.
Yes.
Doctor will have a look at my lord, page 119. It says financial bid opening date 21 February 2025. In between, my lord, the financial evaluation bid list. Lordship will see, my lord, serial number 2. There is a petitioner. Remarks it is nil.
Yes.
This is the result, my lord. And in the next page, my lord, 120. Lordship will see, my lord, again.
Finance bid was rejected.
Bid list, this is the final result. Lordship will see serial number 4. Rejected finance. There is a financial bid rejected. And pursuant to this result at page 118, Lordship will see the reference. This is the issue of notice to proceed with the work. It is dated 12th of March 2025. Lordship will see the reference. This office LOA, that is letter of acceptance, was issued by Lord in favor of the private respondent on 5/3/2025. My Lord, contract has been signed. What I am saying is, my Lord,
His grievance is, if you come to page 119,
that
the price financial bid which is offered appears to be the lowest.
no, my Lord, there may be reason based. That's why the bill
Maybe.
has been
Maybe.
rejected.
Yeah.
So why I am pointing out to page
Prima
118.
facie, it appears that he has offered the lowest bid.
My Lord, just my Lord, offering the lowest bid doesn't mean that, my Lord, he will be offered to the L1 bidder. That's not the rule. Why I'm
No, but
saying
he
is,
should
I'll
have,
have the instruction, my Lord.
but he
Only
should have been shown as the L1.
no, these are computer generated, my Lord. They only by referring to the, my Lord, the amount, my Lord, or the bid value, this has been, my Lord, this is computer generated. The result of the, my Lord, financial bid evaluation committee is at page, my Lord, 119.
That is what we are pointing out.
Yes, 119 and, my Lord, 120.
Almost
Then I will place, my Lord.
in
Now,
every-
why I am pointing out to page 118 is, my Lord, that letter to proceed has been issued, my Lord.
No, but
Agreement has been signed. What I pray is, Lord, will, my Lord, post it, my Lord, immediately after vacation. I'll have the instruction, my Lord.
My lord, what they do, my
No
lord.
point, my Lord.
Kindly,
We are not inclined to grant a stay, but we are only asking you that why it
So
appears.
that I will have the instruction.
my lord, kindly,
Yes.
my lord, kindly consider one thing, my lord. Here, my lord, the letter of acceptance was issued, my lord, on 5/3/2025, my lord. My lord, these financial bid, my lord, these documents were uploaded on 4th of April, my lord.
That's a different.
No, my lord, not different issue, my lord. Because, my lord, they waited. Actually, my lord, it was incumbent on the part of the respondent, my lord, on the issue of, on the date of issue of the LOA, my lord, they should have uploaded these documents, my lord. They did not do that, my lord.
Even then,
They
my
had,
Lord, the petition has been filed now about, now it's almost 1 month.
no, my lord, 4th April, I got the document, my lord. 4th April, they have uploaded 4th April.
It will be very.
My lord, what, in every case, my lord, yesterday one case, there, my lord.
Assuming we state, it can't be granted to you. Your work order has not been given to you. It was given to somebody else.
My lord, here, my lord.
So we'll have to decide whether your grievance that you have not been shortlisted is on grounds which are not germane, is correct or not. That's all.
My lord, yes, my lord.
So
Here,
that
my
will
lord, is
require
always
some-
can do, my lord.
On
Here, my lord, as per
23
close 31, my lord. It is always the L1 bidder, my lord.
No, correct. But for what reason you are not termed as the L1?
Yes,
You are
ma'am.
not shown as the
Yes,
L1
yes,
bidder.
my lord. Yes,
That is what we want
yes,
to find
yes,
out. Heard counsel for the party.
my lord. Only my prayer, my lord. Status quo, my lord, may
that
maintain.
already-
Otherwise, my lord.
He will be subject to outcome of that.
Subject law.
It can't be status quo. This is public work.
That is why, my lord.
Your grievance,
Yes, my lord.
assuming you are correct,
My lord.
assuming whatever you say is
My
correct,
lord,
you can be remedied. You can be remedied
my lord.
by giving a compensation. That's all.
My lord. My lord. Yes.
And my lord,
That
this
can
is the
be-
It's a
construction of his
matter
road,
of
my lord.
it's a
It's
matter
not
of
that, my lord,
contract.
My
You
lord.
have a right. You have a right
Yes, my lord.
to participate. You are allowed to participate.
My-
According to you, you have not been shortlisted.
My lord. I am happy.
I would like.
Heard learned counsel for the parties. What do we issue notice?
Because there is a private respondent. Otherwise, my lord, I can place the instruction on 25th of April.
All right. All right. Then let it be on 25th.
My lord.
My lord.
Mr. B. Gogoi Learned Additional AG representing the respondents.
One to four.
PWT
My lord, Peter.
will obtain instructions in respect of the financial evaluation bid undertaken, where prima facie, although the petitioner is seen to be the lowest bidder, he was not shortlisted as the L1 bidder. Stop. Let this information be placed before the court on the next determinable date. This according, it is taking into consideration the submission of the counsel at the parties, counsel for the parties, that the work order has already been issued to the private respondent. Prayer for interim will be considered again on the next returnable date. List accordingly. Meanwhile, the counsel for the petitioner will furnish extra copies the to the council representing the PWD within 2 working days. List
By
accordingly.
today, sir, my lord, tomorrow is
Yes,
the
I-
last day.
I-
But it's a
2 working days.
Yeah. Let us say, happy with the outcome of the decision.
We have not said anything.
My lord.
We are giving you liberty to press your interim again on 25th.
My lord.
We'll see. 25th.
Public.
Yes, Mr.
I
Gogoi.
got a written instruction. Well, it was placed before the finance department, but the finance department regretted the proposal and instructed the PWD to submit again in April 2025. So they are not initiating the process to be submitted within this financial year.
What was the direction here?
There was payment of the contractor's bill, Malad. Of course, Malad, following Tamsir Ali, Malad. In our case, there was someone, Malad, who had submitted bill later on, was, Malad, given precedence over our bill, Malad, and he has been paid. Whereas, Malad, I stand left out. Malad, it's a work, Malad, was completed in 2015, Malad.
They will proceed in May, my lord. By this time, my lord, if the proposal is submitted, my lord, I can pay the second. They have to come from the division matter, from the concerned district, where the work was executed. Then they can, my lord, apply it for the.
What is the status of the executive PWD? Have they?
Yes, my lord. In the last line, they have stated that, my lord, now they are waiting for the proposal from the division.
This was
Again, my
issued
lord,
on
fresh
8
proposal will have to be submitted.
8/4.
So let it be in the first week of May, my lord.
Yeah.
To be given the authority to expedite.
So if the
My lord.
A copy of that will be given to you.
I will provide a copy.
Malad, I can also pursue the matter.
Heard counsel for the party, Mr. P. Gogoi, additional lady appearing for the PWD, submits on instruction that the matter was placed before the finance department, and the finance department has rejected the proposal, but has requested the PWD department to submit the proposal afresh. So he submits that the finance department is now awaiting fresh proposal to be received from the PWD department.
So when the time is in for PWD, finance is not a part.
Finance is not a part, so right? Representing the PWD department. As per his instructions, finance is now awaiting for a proposal submitted by the PWD department. Council therefore submit that the matter be listed month of May, second week,
On 14th,
14th May,
Obliged.
14th May, by which date you will apprise the court as to the fresh proposal that may be initiated from the PWD department. Placed accordingly.
Wait, please, Malad. The notices issued upon the respondent, Malad, that return answer, Malad, owing to insufficient address. Owing to the address being insufficient, as seen from the office note, Malad. It's the same address as the one mentioned in the agreement in question.
Dusty is also permitted.
Dusty is permitted, Malad. I'll file the affidavit, Malad. We could not trace him. Malad, may I also be permitted to
serve him through email and WhatsApp, my lord, because the notice also was served eventually through email. It is part of the record.
Don't know. If you can't find him, then how are you going to resolve your dispute?
My lord, the notice under section 21 initially, that also was answered. Thereafter, my lord, we served him through WhatsApp and email. That is there, my lord's interpretation. And then he responded. He replied to the notice.
So you find out the proper address and serve him.
Well, the address is the same as the one mentioned in the agreement.
Then you go for a dusty service.
My lord.
You have been permitted to undertake that.
My lord.
Counsel for the respondent prays for further 2 weeks' time to complete the service by dusty as permitted. List accordingly after 2 weeks.
I'm deeply.
Yeah.
Lordship, Mitra, I have advised them. Some more time may kindly be granted for a class. Just directed to make verification.
Oh, the direction is very clear to the
Yes.
commissioner.
Yes.
So it appears that the commissioner has issued a letter and forgotten about it.
Lordship, yes, Your Lordship.
So you'll have to make him
One last
understand that the
proposal, Your
direction is against the commissioner.
Yes.
Either you comply it or you take steps to rectify modify the order, the direction.
Your Lordship, some more time may kindly be given. Your Lordship. I have advised
My
them.
lord,
Let them get the instruction there.
yes, my lord, this letter is after more than 1 year of the order.
Whatever it may be, we are trying to see if the order can be complied with. Then we'll decide whether contempt is required to be issued or not. Heard counsel for the parties. Stop pursuant to the earlier order dated 9/4/2025. The warrant and the rejection appeared on behalf has appeared before the court. The request of the court. The war submits that he be permitted some time to complete the instruction that's in respect of the compliance of the direction contained in the order given when passing the
Lordship, after the election is over, Your Lordship.
when is the election?
Election is process is started, Your Lordship. It will over on 11th of May. Yeah, after 2 weeks. Your Lordship.
Already an affidavit is filed, my lord, on record. Already affidavit.
Some technical indications are there. Your Lordship. I am not on this. Your Lordship. I am trying to help you.
Mr. Poor, on the other hand, also submits that in view of the ensuing panchayat elections scheduled to be held during the later part of April and May.
May, Your Lordship, on 11th of May, counting days.
In the month of May, which will culminate on 11th of May, as per the schedule issued by the competent authority. We submit that the matter be listed after 11th May, so that the matter okay. It's again. Then we'll list it on immediately thereafter.
Your Lordship, Your Lordship, the physical verification has to be done by the district commission. So, Your Lordship, the returning website.
My lord,
Your Lordship.
there is no order for physical verification. My lord, the petitioner is a vendor, my lord. He supplied the materials, my lord.
We'll fix it on 19th. Let us see what materials.
Your Lordship, can it be on 26th of May? 26th of May.
This is too far out. It's a contempt proceeding.
Yes, Your
Not a
Lordship.
writ
I understand, Your Lordship. I am trying to help the petitioner.
Order is of 23, my lord. 23.
Mr. Warren submits that the matter be fixed again on 26th of May. enabling him to obtain instructions towards compliance of the directions contained in the order dated 20. Considering the submissions made by the learned individual lady and also the submissions on behalf of 26th of May.
Obliged.
Do you want a copy of the order marked to you? A copy of this order be
Yes.
marked to the office of the learned additional lady, Mr. K. for onward communication and compliance.
Obliged.
This case that we are asked to look into.
Lordship, I am appearing for response number 2 and 3, Lordship. I have filed my wakalat number today only, Lordship.
Someone has filed an affidavit of dusty.
My lord. My prayer is, my lord, let it go back to the board, my lord. Let the board take, because ultimately it's a question of whether there is a violation or not, my lord. What kind of violation? Let it go to the board, and let the board take a call within a particular time frame.
Lordship, fix it. If it is possible tomorrow or on the immediately on the reopening day.
After reopening.
Yes, Lordship. Because I think maintainability is also there, Lordship. It seems to be a private dispute, Lordship.
No. It's not a
Invoking
private
of
dispute.
226, Lordship.
Get your instructions.
Yes, Lordship.
Mr. Dr. appears for the petitioner. Appears for respondent number
2 and 3, Lord.
2 and 3. He prayed for 2 weeks time to complete the instruction. 28
Lordship.
of April.
Deeply obliged.
Have you received copies? You have received copies.
Lordship, yes, they have provided. Obliged.
Service has completed your still, despite service has been made. The response number 1 not prepared. Your receipt. So Lordship may proceed the matter ex parte against the response number 1.
There was a mediation.
Mediation has been failed. Your
The service is complete through Dusty.
Dusty, and affidavit also filed. Your
Yeah, but it is also necessary to take
yes,
by registered post and AD. To take steps. Let us the learned counsel for the petitioner has submits that service by way of Dusty has been effected and an affidavit of compliance their effect has been filed. So where is that receipt?
in my affidavit, annexure A.
Your Dusty affidavit is filed on
4/11.
4/11. Yeah. Yes. So where is that receipt? National projects.
National project.
Construction corporation.
Yes. NPC.
NPCC.
Yes.
Right, then say has been completed by Dusty and
visual processor.
And the copy has been found to be received on 2/9/2024. That apart, service by usual course has also been detected on the respondent. However, none has appeared.
Respondent number 2 appeared, but have not filed any objection till date.
Rules for respondent to Ministry of Home Affairs.
Home Affairs.
CGC. Any CGC here? CGC. Wait for some time.
I think
with it. PWD has filed an affidavit today. I think they served a copy on me today, just now, while ago. So that affidavit might not be on record.
It is not on record. I would file the.
You have filed it.
Yes, I have filed.
Let me
You are objecting.
But basically, we said that there is a prohibiting a lot. In fact,
Whatever it may be, so let it come up after
Yes.
the reopening day,
Yes.
along with the
I
affidavit.
also go through, if required, I'll file objection.
Mr. R. Sharma appears for the petitioner. Mr. D. Nath, senior government advocate, appears for the respondent with three. Mr. Nath submits that an affidavit has been filed today. Stop. The same, however, is not connected to the case record. Let the matter therefore be listed again on in the month of May. May?
April. Last week, 29.
30. 30th of April. Stop. The petitioner may file. Petitioner is at liberty to file rejoinder if so advised. Registry is to trace out the affidavit stated to have been filed by the respondent and connect it to the case record.
All right.
I think 14.
In this matter, my lord, we appear for respondent number 8 to 10, my lord. I took a slight accommodation, my lord. I'm led by Mr. R.P. Sharma, senior man.
3-4 times they taken this. Today is disposal, my lord. My lord, affidavit, there is no locus standi even, my lord. Affidavit filed by the government, affidavit filed in forest department, now ready to demolish the embankment, my lord. Is the government land, government fishery, my lord. Maybe I may be hard, my lord. Today may be dispose of matter, my lord. I may be hard, my lord.
I'm just paying for slight accommodation. Timing.
Time being.
My timing.
Right. Time being.
Yes.
Time
Timing. Timing.
This is against the blacklisting of the petitioner, my lord. Here, what happened, my lord, you also find canopy, my lord, was LOI was issued for construction of canopy for a petrol pump. So normally, my lord, petrol pump, my lord, canopy is 4, my lord, stand, my lord. But here, what happened? This is a B side. B side is, my lord, always maintained by the party, my lord, not by the company. Here, they have given a canopy for construction on 2, my lord, stand. My lord, that you will also find, my lord, that canopy, it was issued on 12/3/21. And work order is issued on 22/9/22, my lord. That you will also find at page 38, my lord. 38.
This matter is for what? For disposal today.
Disposal of stay or disposal, my lord, whatever it may be, my lord, because the stay matter was also not hard, my lord.
So,
So it can be disposed of, my lord, it's very simple. Simple matter.
You are agreed by which termination order?
No, blacklisting order.
Where
I'm
is-
not termination, my lord. We have completed the work.
Okay.
Then defect liability period of 1 year expired.
Thereafter it collapsed.
Thereafter, after 3 months, my lord, what happened? There was a severe wind and the canopy, my lord, fall down, collapsed. And on that basis, my lord, their reports are there, their plan is defective, my lord. I'm placing that, my lord. And moreover, no hearing has been given. Now the latest judgments are.
Where is that order of blacklisting?
Yes. Page 65, my lord. Or purpose has not been considered.
65.
60, 69, 69, my lord. 69. It's a long order, my lord.
No, but this it appears that some show cause was issued to you.
Only so called, my lord, no hearing. Now, my lord, the latest judgments are there, my lord. It was development, development, my lord, the Supreme Court, that hearing must be given, my lord. And now your office may see page 74, my lord. That is the paper cutting I have. Why it has been.
74.
Next.
No, that's okay. We are not
Now,
disbelieving the ground.
their own, my lord, I shall place their own, my lord.
So where is the judgment of the apex court
Yes,
saying that hearing is necessary?
My lord, yes, thank you. There are several judgments, my lord. First, my lord, I am placing this, my lord, 21 to SCC. Paragraph 13 to 19. Okay.
Yes.
Paragraph 13, my lord, at page 558.
Thirteen.
You also got to, my lord?
Yes.
At the outset, it must be noted that the first principle of civilized jurisprudence, that a person whom action is thought to be taken or whose right or interest is being affected should be given a due opportunity to defend himself. Basic principle of interest is that before adjudication starts, the authority concerned must give to the affected party a notice of the case against him so that he can defend himself. Such action, such notice should be adequate and the grounds necessitating action and the penalty action should be mentioned, especially an ambiguity. An order traveling beyond the bounds of notice is impermissible and without jurisdiction to action. The court in Nasir Ahmed so held that essential for the notice to specify the particular grounds on the basis of which the proposed action is to be taken to enable the noticee to answer the case against him. If these conditions are not satisfied, the person cannot be said to have granted reasonable opportunity of being. Especially in this context of blacklisting of a person, an entity by a state or a state corporation, the requirement of a valid and particular and ambiguous so-called notice is particularly crucial due to the severe consequences of blacklisting and the stigmatization that accrues to the person and the blacklisting. Here it may be gainful to describe that the concept of blacklisting and graveness of the consequences occasioned by it. Blacklisting has the effect of denying a person or an entity the privileged opportunity of entering into government contact. This privilege arises because it is a state who is the counterpart in the government context, and as such, every eligible person is afforded an equal opportunity to participate in the context without arbitrariness and discrimination. Not only does the blacklisting take away the privilege, it also tarnishes the blacklisted person's reputation and brings the person's character into question. Blacklisting also had long-lasting civil consequences for the future business prospects of the blacklisted person. In the present case, as well, the appellant submitted serious prejudice has been caused due to corporation's order of blacklisting, as the several government corporations have now terminated their contract with the appellant and have prevented the appellant from participating in future tenders, even though the interim blacklisting order was in fact limited to the corporation of Madhya Pradesh Regional Office. This dominion effect, which can effectively lead to the civil death of a person, shows that the consequence of blacklisting travel beyond the dealings of the blacklisted person with one particular government corporation, and in view thereof, this court has constantly prescribed that adherence to the principle of national justice, whatever an entity is thought to be blacklisted. The severity effect of the blacklisting, the resultant need of the strict observance of principle of national justice, passing the order of blacklisting is highlighted in the court of Irrisian so and so. Well, these are given, my lord. I am speaking about. My lord. Now your losses may come to, my lord, paragraph 17. Next page.
Yes.
Similarly, in Raghunath Thakur, around blacklisting future contracts on the ground of non-observance of principle of national justice, the relevant aspect so and so. They implied the principle of rule of law that any order having civil consequences should be passed only after following the principle of national justice. It is to realize that blacklisting of any person in respect of business ventures has the civil consequences for the future business of the person concerned in any event. Even if the rule does not express, it is so elementary principle of natural justice that the parties affected by an order should have a right of being heard and make defense against the order. Now, paragraph 19, my lord. In the light of the above decisions, it is clear that prior so-called notice granting a reasonable opportunity of being heard is an essential of all the administrative decision making, particular so decision pertaining to the blacklisting, which entail grave consequences for the entity of the being blacklisted. In these cases, furnishing a valid so-called notice is critical, and failure to do so settle the blacklisting person.
I think para 21 is.
Yes, para 21. That is the important. That's it. That's it. From the above discussion, a clear legal position emerges that for a so-called notice to constitute valid basis of blacklisting order, the such notice must spell out clearly in context, such that clearly inferred therefrom there is intent on the part of issuer notice of blacklist the notice. Such a clear notice is essential for ensuring the person against the penalty of blacklisting intended to purpose has adequate, informed, and meaningful opportunity to talk against the possible blacklisting. The case whether the regulation so well, yes.
So
now another judgment
what is there in the judgment? What is contemplated is a clear notice. It's a notice.
Notice not hearing, my lord. That Raghunath Thakur, my lord, that has been closed, my lord. You can also see 23.6. I'm
23.8.
Yes.
8 SCC.
23.6 SCC.
23.6 SCC.
Well.
Yes.
Paragraph 60, my lord.
Rajesh Agarwal.
Yes. That's
paragraph?
Paragraph 60. 60 and 65, my lord. 60, 65 and 98.4. My lord, this Raghunath Thakur has been quoted where it was said that the hearing is to be given. Then 65, my lord. The competence of RBI to issue the master direction on the frauds is not a bone of contention in this appeal. RBI, in its estimation, has the power to determine and frame the economic measures in public interest to ensure the proper management of banking community. The point is, however, that the implementation of the decision to secure health of the banking companies must comport with the process of law. Civil consequences which follow the classification of the borrower's account for serious prejudicial to interest of borrower. Principle of fair play require that the borrower ought to be given an opportunity of being heard before justifying the account to a fraud in accordance with the procedure laid down by the master decision of the court. Now 98.4, my lord.
Yes.
That is regarding debarment, my lord. Subsequently, debarment has been considered. Now, at page 47.
Yes.
98.4. Such a debarment under clause 8.12.1 of the master direction on the frauds is akin to blacklisting of the borrowers for being untrustworthy and unworthy of credit by the bank. This court constantly held that an opportunity of being heard to be provided before a person is blacklisted. And the Raghunath Thakur case is also there, my lord, the earlier case. And now here another aspect of the matter is there, my lord. Here what happened? If you also see, my lord,
This is in the face of some master directions by the SBI, by the RBI.
yes, but the 98.4 is clearly, my lord, that says, my lord, that
No, this is in the facts of the case.
Yes.
I don't think this is a general proposition that
general proportion that in blacklisting, my lord, that is should be given, my lord. I am referring to another decision, my lord. This 89, my lord, that Raghunath Thakur case,
Yes.
that is clear, my lord. And another judgment is there.
yes, para 4.
Yes. Then this daffodil case also, my lord, if you also see paragraph 14 and 15.
You are referring to which judgment?
This 2020 18 60 550.
No, but the earlier 98, 89 judgment?
89 judgment is yes, man. That is para 4. Para 4. Indisputably, no notice was given to appellant to proposal of taxing appellant. Content that on behalf of the state government that the person, there was no requirement in the rule giving prior notice of taxing person. In so far the contention that there is no requirement, especially in notice concerned, the respondent has right, and it is implied principle of rule of law that any order having still consequences to be passed only after following the principle of justice. It has to be realized that blacklisting of a person in respect of business ventures has civil consequences for the future business of the person concerned in any event. Even if the rules does not express so, the elementary principle of the party affected order should have a right of being heard and making a remission against the order. In their view, the last portion of the order insofar the direct blacklisting of the appellant in respect of future context cannot be sustained in law. In the premises, the portion of the order. And now this innocent judgment paragraph 15, my lord.
So you were referred to again 2020 volume 18.
18. 550, paragraph 15, last page.
Para 15.
Paragraph 15.
Yes.
In the present case, even if one assumes that Chandra Chaudhary, the accused in the pending criminal case, was involved and had sought to indulge in objectionable activities, that ipso facto could not have resulted in unilateral action of a kind which the state has resulted against the opposite, which has never been granted in the opportunity of being opportunity of hearing a chance to repent against the impending order. If there is one consistent also for the light of horizontal in the country is this, that no one should be inflicted with an adverse order without being afforded a minimum opportunity of hearing and prior intimation of such. The principle is two hands in suspension. Now here another aspect of the matter is there, my lord. I shall rely another judgment also. Your losses may just see that what happened here. The canopy was completed, my lord, on 21/1/23. Now the 1 year liability period was expired, my lord, up 21/1/24. Now the canopy collapsed on 24/24. Now their own, my lord, they have investigated it. Now your losses may see their report, my lord. First, my lord, your lordship will see the report of the ITI, my lord, IIT, which is at page 108, my lord. Our editorial 108.
Is there any recent tender which you are trying to?
Yes, we are trying, my lord. We don't get it.
108.
Yes, 108. This is, my lord, because they have done it. The construction of petrol pump so and so, so and so, so and so, and they are doing this from so and so. Guwahati. The design of the drawing was checked as per the cordial provision. After analyzing it, has noticed that members used to design truss or canopy was insufficient to withstand the wind pressure. The member used to in the top and the bottom boards of the grinder curling state. It is recommended that the truss is being redesigned with adequate members and sizes of the drawing itself is wrong. Now they themselves have admitted, my lord, their committee, that your lawsuit will find at page 153, my lord. First 153, then later on. Your lordship, what is, my lord? Page 153. Design related deficiencies, my lord. There.
Page number?
Page 153 of their affidavit.
Yes.
They have said, my lord, what the design related deficiencies here.
Yes.
Para 1 is important, then thereafter, my lord, the next page, para 154. Para 4 and 5, my lord, your lordship machine. Para 3, second part. In the canopy design, there are structural members like basic plate, gap plate, stiffness with a thickness more than 6 mm to 20 mm. A general statement of wheel thickness of 6 mm appears to be insufficient at the joint involving these members' higher thickness. The design calculation sheet lacks the analysis or calculations for the column, base plate, anchor bolts, gap plates, so and so. The absence of suggests that canopy may have been designed without accounting for all structural members and connections required to transfer loads for the superstructure of the foundation. As the as per truss design result, only the main secondary beam have been shown. Results considering the entire canopy, including the fascia beam, column, cap plate, base plate, and corresponding structure shown that submitted the drawing is not provided. Now, I am coming to page 176, madam. 176. Your losses may take up the mallet at page 3rd para. On 20th April, your losses got it at page 126.
Yes.
On 20th April, around 2 a.m. in the morning, it was reported a strong wind blowing with heavy rain.
Sorry, we are not
at page 176.
176. Is it a part of the affidavit?
Yes, part of the affidavit.
Para 6.
Para 6. No. My lord, this is R5, my lord. R5. R5. Annex R5.
R5.
Annex R5.
R5.
So, what, my lord?
Yes.
The on 20th April 24. You lost, you got it? At around 2 a.m. in the morning, it was reported that a strong wind blowing with heavy rain had hit the subject area due to high velocity of the wind, heavy thunderstorm, and heavy rainfall. Newly installed canopy structure fell in the retail outlet premises, leading to damage of the canopy structure and RB element. The high velocity of wind, heavy rain, fall causes tilting, toppling the canopy supported on the members, supported on two numbers of column towards the right side. This is one, my lord. Next, your losses may come to next page. Next page, my lord. Root cause of the incident. That is their report, my lord. Page. The quality of both construction, job, and material are inferior. Just one. The poor level of inspection by TPI, so joint site. The design was not site specific. The design was not site specific, and also the design was not followed by the contractor, not following the standard procedure of fabrication using so and so. Design was not site specific. Now, my lord, here, next, again, my lord, your lordship's map, skip one page and then next page, 179, my lord, in my. This is 179, my lord. No.
Yes.
Here, paragraph 6, my lord. RO's commission so and so. Initially, budgetary estimate for construction of whole column canopy was prepared. My lord, you'll also see. Because normally, my lord, in their own side, the column canopy is there. Revised budgetary estimate of 2 column canopy was prepared later, approved by DRSH. Now, what happened is, I am coming. Now, your losses may come to page 181, my lord. Cause of the incident. Design was last parameter.
Yes.
Poor design, layout, etc. Design was prepared not considering any site specific conditions. Wind speed consider 50 m so and so against actual requirement of 55 m so and so. Drawing not specific about the welding joints. Detailed connections between the column cape plate, main plate cape plate missing. Column being the same on the row. Failure of the beam column junction by tearing of the welded joints leading to toppling of the canopy structure. Now, my lord, last, my submission is at page 184. Appellate. Design not prepared as per site specific condition. Drawing not specified about the welding joints and details of connections between column, cape plate, and main beam missing. Poor quality of welding so and so. This is our state. Improper quality of inspection by TPI so and so. Quality of compromise during construction of job so and so. Construction not as per design. Lack of inspection during after action. No records found pre-monsoon canopy deck as per so and so. Justification for revision of budgetary estimate from 4 column to 2 column could not be produced. So, well, this should have been 4 column, my lord. They have prepared it as a 2 column, my lord. And here the wind is so high, my lord, that the faulty design, then wind is high, my lord, and for that reason, my lord, it has been done. Now, I am producing a judgment from Supreme Court. My lord, here, when, my lord, when blacklisting cannot be done, my lord, when both sides are involved, my lord. This is a very important judgment so far this is concerned, my lord.
Yes. Paragraph?
Paragraph 40, my lord. I shall not read the entire my lord part. The line about 12.
40.
40. Last page.
Yes.
The written submission, you notice, my lord?
Yes.
On behalf of the respondent, do not answer the root question in the matter as to how the appellant could have made the solely responsible for the delay or default in supply after a communication dated so and so. When the respondent themselves informed the appellant that taking of the balance delivery was being deferred. In length and breadth of the arguments on behalf of the respondents, it has nowhere been pointed out that if other instructions were ever issued to the appellant before issuance of the cancellation order dated 19/11/19 and 21/11/19, also before issuance of so-called notice dated 26/11/19. That being the position, we clearly have the view that department order had been issued against the applicant without due regard to the undeniable factual situation, where the entire blame could not have been posted upon or shifted towards the appellant. So this is I am happy. The entire blame could not be posted upon me, my lord. Hence the issuing order so and so debarring the appellant is absolute. Here, my lord, the drawing is faulty. Then wind is heavy, my lord. Due to the wind, my lord, I have there paper cutting, my lord. Due to wind, it has been held down. And moreover, my lord, the warranty period expired on 24/1/25, 24. And this happened, my lord, on 20th of April 24. So in such a case, my lord, my humble submission that, my lord, the blacklisting is absolutely wrong, my lord. Because neither I have been given a hearing, and in such case where they themselves are at fault, my lord, so far drawing is concerned.
No.
And moreover, it is a natural, my lord. Here. And secondly, my lord, there is a, in their executive instructions, my lord, they have provided an appeal, but this is a case, my lord, where no hearing has been given. That is why, my lord, I say that this case is covered by the judgment of the Supreme Court that the alternative remedy cannot be, my lord. And in this respect, my lord, I can rely on latest judgment also.
What is the
That's
name?
the same thing, my lord, from 98, my lord, it is coming. That for para 10 only, my lord. Para 10 only. This,
yes.
So, that breach of fundamental right, violation of peace and natural justice. Access of jurisdiction, challenge of violation. These are 4 grounds, my lord, that from 98 it is coming. So here, my lord, no hearing has been given to us, my lord. There is no aspect. Secondly, it is, my lord, not my fault, my lord. They themselves are at fault, my lord, because the drawing is, my lord, defective, which is admitted by their own, my lord, as well as by IIT, my lord. And moreover, there is a heavy wind, my lord. The natural, my lord, calamity. For natural calamity, it has fell down. So I cannot be blamed fully, my lord.
Drawing was not by you.
No, they provide the drawing, my lord. That is why, my lord, it is said that, my lord, originally, my lord, fund was provided for 4-pillar canopy. Then they have again shifted to 2-pillar canopy because it is a B site. B site is maintained by the party, my lord, not by the company. Here they have to done everything, my lord. That is why, my lord, they have done it to 2-pillar canopy. And that is why, my lord, I have relied on this last judgment of the Supreme Court that when they are also at fault, my lord, I cannot be blamed at all, my lord, fully. Suppose there is some check, my lord. Even then, I cannot be blacklisted, my lord.
Please, your lordship. My lord.
Yes.
My lord, before going on to the legal issues raised by the senior counsel, I'd like to present a certain facts for your lordship. The issue in the show cause notice, if my lord takes up this page 63, there is one clause I would like to draw Lordship attention. Page 63, clause C. I'm not even in the merits of the case. I'm on just on this clause C. It leads to a certain inference. The Lordship should have to note. Deviation in construction from the provided drawing. Drawing is provided. Deviation in construction. Design single bracing observed in place of diagonal bracing and gusset plate missing. This is the allegation. On the side, there was the reply. This is the reply to the show cause notice. The reply of petitioner is that there was no deviation. All bracing and gusset plates were installed according to the design specifications. Furthermore, the third party agency recommended by IOCL. Now, this IOCL party is, my lord, is known as an ARD Associates, who inspected the canopy. These documents, my lord, the ARD Associates has also been blacklisted, holiday listed for a period of 2 years. Number one, by order dated 22/8/2024. This is not on record, my lord. Secondly, my lord, this same TPI has approached the Honorable Patna High Court. They had initially gone on departmental appeal from the order of holiday listing. That departmental appeal could not be adjudicated because all these 6 months their writ petition was pending. In their writ petition, ARD Associates, although they are relying on the certification provided by the ARD Associates, they have not made this this firm a party hearing. Therefore, we as the IOCL, we are unable to adjudicate the departmental appeal preferred by ARD Associates. Secondly, therefore, they came before the Honorable Patna High Court stating that their appeal was languishing for the past 6 months. IOCL could not take a decision because they had approached this honorable court without preferring the departmental appeal. Secondly, there in that yes,
they had who had a Patna.
The third party inspector who has purportedly inspected the canopy.
Party here.
Is not party. They separately approached. Their grievance is separate that they have been holiday listed, and their departmental appeal is not being adjudicated.
Whose department?
Their department. Because of the pendency of the present writ petition.
Where have they preferred the appeal?
Patna High Court.
Departmental appeal?
Before the office of the IOC. Not here, my lord. This is before the regional office, Kolkata. Because, my lord, if it is because second part is that in that writ petition, they have averred that they never inspected the canopy. They were never given a work order. They have never certified that so and so canopy is fit. Therefore, my lord is faced with a contradictory set of averments in this writ petition as well as before the Honorable Patna High Court. The reason being that none of the parties have made each other party in the two litigations. So my first submission is that, my lord, if my lord desires to hear this matter on merits, imperative is that the TPI, my lord, to proceed to hear on merits to pronounce in the yes, my lord. My lord, my submission is that there is a non-joinder of a vitally affected party who has given a contradictory averment before the Honorable Patna High Court. This is the I have even the petition copy as well.
No,
my lord, that is the question is that there is a judgment of the Honorable Supreme Court in Patel Engineering wherein the issue of question was posed by this Honorable Court that they were given a show cause notice. They have replied in detail to the show cause notice whether an oral hearing is required. At para 26, which I'll be submitting to Lordship, coming to the submission that respond to out to have given an oral hearing before the impugned order was taken, we agree with the conclusion of the High Court that there is no inviolable rule that a personal hearing of the affected party must precede every decision of the state.
Is this prior to the judgment or after?
This is 2012.
Well, so subsequent judgments have.
Yes, my lord, that is their view. But my submission is that personal hearing can also be done by the Appellate authority. If they desire to put their experts, that can be done also. That was the.
It may be. But who has passed the order of blacklisting?
Well, that is the order. This is the authority here at present in the state office.
So why should it be done before the appellate authority?
Well, because
the hearing is to be done, it has to be done by the authority who has passed the order.
Yes, my lord. But because they have given a detailed reply in the show cause notice without addressing that.
They are asking. Say with that proposition.
Only on the issue of personal hearing, that was my point. That oral hearing is not a mandatory.
But
yes, my lord.
Address the court.
Yes, my lord. This judgment.
No, not their judgment alone. The judgment before this court by the petitioner. Court the judgment that we are fighting by the apex group.
My lord may take it up on that issue on 21st. On that limited issue, I'll address it on that.
Yes, sir, time.
But is a case, at least it has to be granted.
Stay for what?
Stay of that blacklisting.
That can be set aside.
Hello?
We are already hearing the matter.
Only on the limited point that I left it, including all the judgments. If in case there is another, there are more judgments on the point of oral hearing.
You place whatever, but uh, you are a contractor in the IUCL.
Yes, my lord.
Because of these holiday listing, you are unable to participate.
My lord, yes. Unable to participate any other company also, my lord. Nowhere, my lord. And my last payment has been also blocked, my lord. I said. That should not have done.
That I will instruct. That is not, that should not be done.
Did you pray for an interim order? Was
Yes,
it
my lord.
rejected?
Yes. No, not rejected, my lord, because they were not appearing on, my lord, because they are not the extending counsels nowadays. That is the difficulty, my lord. So court says that notice to be served and then we shall hear it. 6/9/20. And thereafter the matter could not be heard, my lord, only the appeal.
Liberty was granted to consider it on the ground on the next returnable date.
Yes.
Perhaps no prayer was made.
No, my lord, it could not be heard, my lord, actually. For one reason or other, my lord, the matter is adjourned.
So we keep it after the reopening. Heard Senate Council. Then again on 23rd.
Malone, keep it on 25th, Malone.
20, not 25th, sorry. It has to be on 29th.
29th.
29th of
Some
April.
further hearing.
Further hearing. For further hearing.
29th.
The counsel for the petitioner has concluded his argument. I matter fixed for argument of the respondent. Yeah. List again on 29th April.
My lord, matter may be taken after some time. Came to the
You have been
circulation.
making the same prayer for the last 2
No,
weeks.
this is another matter, my lord. That was another matter.
That was another matter.
That was another matter. So there is a election code number 12.
All
Will
right.
come shortly.
After some. Yes.
That has come on record. The matter was first came on 27th to 25.
What are you aggrieved in the first place? What are you challenging?
Challenging is this, my lord. Challenge is this, my lord. There was a complaint against my bar license. It was a complaint in 2023 by some vested interested person. One of those person was my elder brother and his wife. There were many criminal cases, civil suits. They tried to close down my restaurant cum bar, but they failed. There are reports from the deputy commissioners itself that the complaints are baseless. Even after that, they have created some new mayhems and some new chaotic situation. Having into gloves into hand with the police, they have not only closed down my restaurant or suspended my bar license, they have closed down my residence also, which is attached behind the restaurant. I have a mother of 80 years old, and now we are living in a neighborhood in a rented house. And my respectful submission, I will come to the documents later on.
Now, you have arrayed some officers in their individual capacity.
Yes, they are.
Who represents them?
No, notice is not
Notice
yet
is not issued.
issued.
Lordship on the matter first came on 27th to 25. Then Honorable Court has directed us to produce the police report, which is mentioned in the Deputy Commissioner order.
I'll come to
And
everything.
accordingly, on last occasion, Lordship, Honorable Court has directed us to bring on record those police reports in way of an affidavit.
Where is that police report?
Lordship, if your Lordship takes up my affidavit,
I'm coming to me, Lordship.
Let's quickly look through the.
It starts from page 54, Lordship.
54.
54.
This is a report of November.
Yes.
Yes, that.
Then Lordship, next page, Lordship, the report of the OC is also there. Three reports, Lordship says that there are 6 criminal cases pending against the petitioner, Lordship. And
Who has given the license?
a license is given by the excise department.
What has the excise got to do with
The excise is conducting independent inquiry, Your Lordship, regarding this complaint.
Huh?
We are on the process of conducting an inquiry, Your Lordship. Then,
When will you complete your inquiry?
within last week of April, Your Lordship, the inquiry will be completed.
Why so long?
Because Your
You are
Lordship,
the authority giving license.
we are the authority, but the shop was closed down on the order of the magistrate, Your Lordship. Yes, yes. On the magistrate. Because of the
Where is
situation,
the order
Lordship.
of the magistrate?
Yes, yes.
Page number?
At page number 45.
45.
Annexure 5 of the writ petition.
So why no inquiry was done by the excise if it was closed in December 2024? Where in April?
Now, since this report, we have we are also review of the report from the SP. Thereafter, we have to conduct an inquiry because there are certain allegations against the petitioner, Lordship.
You conduct the inquiry.
We are doing it. We are in the process, Lordship. The inquiry is ongoing.
Assam excise.
What is your establishment? It's a restaurant.
It's a restaurant come bar.
On license.
Online. It's called online. IMFL online.
So what is the retail shop?
Pardon me.
What is the retail shop?
It's a restaurant, restaurant.
No. What is the meaning of a retail shop?
Retail is an off license, Lordship, of the premises.
Where do you find it? In the definition somewhere.
Yes.
And the license, the copy of the license of the petitioner, page
No,
28.
under the act and the rules.
Under the act, there is a specific.
Anyway. 52, section 52 is for closing of retail shop.
That is off license. The wine shop is normally. There is judgment of our High Court, Miller, that on license does not attract the closure of under section 52. And the religious institutions, the ground they have shown is also not.
You come to 45, the impugned order is issued under section 52.
52, yes.
52 in the section is for retail shop.
Retail shop.
This is not a retail shop. How have you closed it?
one more thing, my lord. They can suspend my license, but they cannot close down my residence and restaurant.
Resident.
There is an attached room behind the restaurant, my lord, where my 80 years old mother resided along with me. Everything has been closed down. And today morning,
You
I am
reside in the restaurant premises.
no, my lord. Actually, front side of my residence is commercial area. My aged mother, she is alone. She lived with me. There is a attached room behind in the same campus, behind the restaurant. They have closed down everything. And today morning, I am told, my lord,
Allegation is there, they have.
my lord, I am submitting. My landed friend will get time. Need not to be so rush. My respectful submission, my lord. Kindly see the affidavit filed by my friend. See the audacity of a police officer to annex falsified document. I am showing you.
Where is it?
Kindly come to page 57 of that affidavit. This is the translated version.
57.
Okay, my lord, I will take your lordship to the vernacular. Since lordship can read the Assamese, is 63. Yes. See the dates, 18 November 2024. And see the signature. There is no signature at all of any of the person who wrote this in 3 or 4 pages of this particular memorandum. And see the signature on the next page at 67. It is of 6 or 5/11/2024. The signatures were taken before. And nobody has signed this in this Smarak Patra. And my respectful submission, if your lordship pleases, can call for the original signatures where this was done. To my instructions, my lord, there is nothing. It has been a photocopy taken from a different meeting of the locality. And to my instruction, I am saying, my lord, these are not the person who live nearby my restaurant.
Let the commissioner make an inquiry.
Yes, in inquiry.
That can be done. Let the commission make an inquiry.
No, you should have done it.
Lordship, now the issue is that this retail, the 52 says retail. Retail is on and retail is both on and off, both, your lordship.
Where?
There's no definition given, but may I take a lordship to page 124, your lordship?
Oh.
Of the Assam Excise Rule, 160. Page 124, rule the grant of excise license, lordship, at 113D. Here the fee which we take is for new foreign liquor, retail off and retail on. Off means the wine shop, on means the bar.
You are referring to 124?
Page number 120. Page number 124.
Page number 120.
Rule 113. Down below the D. Application fees for new liquor, retail off and retail on.
No, this is
This is the fees we
for
take.
shifting of residence. Shifting of residence.
Yes, shifting. But here the thing is that I want to show that retail is both on and off. Both on and off the lodge. Because they procure this liquor from the warehouse and sell it at retail price in on shop and an off shop.
Okay, third, the party. The pursuant to the earlier order passed by this court, the respondent 6 has filed an affidavit to bring on record the complaints and the complaint made and the inquiry conducted by the OC. So, it's said affidavit, there is an affidavit.
Well, I'm sorry, Miller, to interrupt you. I'm so extremely sorry. Before passing an order, Miller, if Lordship just would like to have a look, Miller, if Lordship pleases, Miller, page 30 of my report. Just have a look. Before, otherwise there may be overlapping of instructions.
Yes.
Miller, page 30. I'm sincerely apologize for it. To the Additional District Commissioner Naga, Annexure 2, has your Lordship got? Order received from Additional District Commissioner Bhaya so-and-so. Complaint received against Greenland Bar and Restaurant, Rimoruguri, Nagaon, owned by Surojit. As per direction, I undersigned visited Greenland Bar cum Restaurant 16 July 23, along with Inspector of Excise Subhas Boisho I inspected the premises of the bar cum restaurant and recorded the statement of the owner, Surajit De. I also collected the relevant documents pertaining to the allegations put by the complainant. Findings of the inquiry. The complainant had alleged that the restaurant was located 200 meters from the Namgarh. However, the Namgarh was found to be located at least 400-500 meters approx from the restaurant. The complainant also alleged that the underage students regularly visited the restaurant and created ruckus. The owner, Surajit De, claimed that there was no such activity in the establishment. However, he was not able to produce any register of customers visiting the restaurant. The complainant alleged that there was no provision for drainage. The owner, in his statement, point number 9, Annexure 1, stated that there was provision for underground septic tank for wastewater and sewerage. He also stated that the solid waste generated was disposed at the dustbin under municipality. Dustbins were seen within the premises of the restaurant during the visit. The complainant alleged that there was no provision for parking outside the bar, which was true at an extent, as there was limited parking space outside the bar. The complainant also suspected nexus between Surajit De, Itasali Police Station and Excise Department, Nagaon. However, the complainant could not give any substantive proof to his allegation. The complainant alleged that there was mismatch between the license and current place of establishment of the bar. The location.
What are you trying to submit by referring to this?
Well, just one paragraph, left, my lord. The location as per license number so-and-so is at Dimoruguri, 80 Road, dark number so-and-so, Pata number so-and-so, which is under the name of his father, Ranjit De. Hence, the above claim mismatch was not found. It was also felt during the inquiry there was personal discord between the complainant Plavita Hazarika and Surajit De. Surajit De is the brother-in-law of the Plavita Hazarika, and there was evidence of several confrontations between Plavita Hazarika and Surajit De in the past.
Yes, so
my lord, this is the inquiry. It has already been done.
Correct.
This is the second. This is the second complaint on the same issue.
Inquiry done by whom?
This is done by the Dhiman Hazarika inquiry officer. This is the additional district.
Who is appointed in the inquiry officer?
By the district commissioner.
Right. So, we want to know what is the excise. You are complaining that your shop license has been
not only shop license was not suspended. My entire setup has been closed down.
Your entire setup, but and you have arrayed the SP and the officer.
Everybody has
right.
a part.
So they will have to be given a notice.
But I understand what my sincere prayer before your lordship, Lord. Until and unless they prove a prima facie case, as per the records, from the records I am saying, lordship has seen the complaint that has been placed before by way of
your submissions are contradictory. Why don't you realize it? You are asking proof. We can't ask for proof unless we issue them notice.
But till then, my lord, at least my restaurant may be allowed to open. My lord.
That will not.
But where is the law, my lord?
We don't know whether it is a restaurant or a bar or whatever is going. Where is the license for the restaurant and the bar? License, do you have the license?
License I have annexed. License I have annexed at page 28. This is the license.
This is license for retail when?
This is the license for, this is the bar license. I'm a full on shop.
Is there a separate license necessary for the restaurant?
That is a trade license, my lord.
Trade license, is it here?
No, trade license I have not.
No.
Trade license I have not annexed. Until and unless there is a trade license, I cannot get the IMFL on license.
So it's purely an on-shop lot.
My lord, what my lordship will issue notice, what I may propose, my lord, if lordship consider. There is a representation given to the excise commissioner. Pending disposal of this case, excise commissioner will consider that bill.
So we can't direct, either we direct the excise commissioner to consider it and pass orders within a fixed time period, looking into giving opportunities to all, or we ask them to file their report as to, in terms of the allegation, what they have to say.
But so far as my restaurant and residence, my lord,
the residents will
under what authority of law, my lord,
we will permit, we will direct them to allow you to use your residence. But so far as the, you see, you are selling alcohol in the restaurant,
my lord,
under a bar license.
Bar license.
Now there is some dispute with regard to the bar license.
It will be kept in abeyance. We will not sell alcohol.
We don't know about the restaurant part unless you show us that your restaurant was in operation. Or
everything was kept lock and key by the police.
No. prior to that, you show us your trade license or whatever fees you have paid that your restaurant was in operation
My lord,
continuously.
until and unless my restaurant and bar was under operation.
No, see, they have, you see the order, you see the impugned order. Where is the impugned order?
Case 45, Lord.
Greenland Bar and Restaurant is closed. Now, whether restaurant and bar are two separate, whether you have been permitted separately to run, I don't know. It is Greenland Bar and Restaurant. Whether we can modify this order to say that no, bar is closed, restaurant.
My lord, then my lord, we issue notice, my lord. In the meantime, there shall be no bar for the excise department to consider with it.
But they can get. There cannot be a time limit for that.
As early as possible, lordship will use the word, my lord, if not inconvenient. Expeditiously as possible.
No, we are examining the matter.
My lord.
Why do we permit an authority to examine the matter at the same time? What is the meaning of that? Either they examine or we examine. Either you allow us to examine it, and if you think that
the difficulty is there.
we can
The moment there is a
we can at best say that in view of the representation pending, there shall be no bar for the authorities to
yes,
dispose it off.
that is what I'm saying.
That is all we can say.
That is what I'm
saying. Pursuant to the earlier order, in deference to the order taken 5, the respondent 6 has filed an affidavit. The reports earlier, the affidavit was filed today.
Today, Lord.
Today. And upon permission being granted by the court, the same has been requisitioned from the registry and a copy thereof is connected to its report. The petitioner is aggrieved, the petitioner is aggrieved by the impugned order dated 16/12/2024, whereby the district magistrate Nogam had issued a closure order of the restaurant and bar and restaurant run by the licensee named the petitioner under the name and style Measures Greenland Bar and Restaurant, Dimoruguri, P.S. Nogam. Stop. The impugned order was purportedly issued on a report received by the Superintendent of Police, Nogam. Stop. This report by the Superintendent of Police has been brought on record by the evidence by the petitioner, besides questioning the legality of the impugned order, further submits that even assuming, though not admitting, that there is some there was some ground to issue orders by the district commissioner for closure of the bar. However, there is no authority to close the restaurant and obligor the entire premises where the petitioner claimed he and his aged mother
were living.
Resides. Stop. But considering the submissions made and also in view of the contentions raised by the parties to the court, and also we've seen that the SP and the officer in charge has been arrayed in their individual capacity as respondents 8 and 9. This court considers it necessary to issue notice to all the respondents. So, Mr. S.R. Burua accepts notice on behalf of respondent number 1.
No, Lordship.
3. Sorry,
two,
number
3,
2.
4.
2. Who is for 2?
2 I am appearing, Lordship. 2, 3, 4, and
2,
6.
3, 4.
And 6.
And 6. And Mr. R.R. Gogoi appears for respondent number 1.
1, 5. 1, 5, and 7.
1, 5, and 7. Since the counsel represents, respective counsel represents respondent 1, 2, 3, 4, 5, 6, 7. Notice the way the extra copy is furnished within. Can you do it within 1 day? No. Extra copy?
Tomorrow, yes.
Within 2 working days?
Tomorrow, possible.
Steps on respondent 8 and 9 by registered post AD as well as usual course. So that's the zone. So respondent may complete their instructions and file its very applicant in the meantime. So considering the submissions made by the counsel to the petitioner that the petitioner along with his aged mother also resides in the premises of the restaurant and the bar run by the petitioner, we direct the respondent authorities to permit the petitioner and his aged mother to use the premises for residential purposes only. So, it is made clear that the petitioner will not attempt to use the bar or the restaurant for commercial purposes until the next 8 days.
Well, in the meantime, my lord, if the commissioner exercises
the
a lot.
stop. It is also in taking into consideration the submission made that a representation has been preferred by the petitioner by which order, which representation?
My lord,
Page
representation
46.
is that, my lord.
Page 46.
Yes, page 46.
It's been prepared by the petitioner before the Commissioner Excise, dated 4/3/2025, ventilating his grievances, the liberty is granted to the Commissioner Excise to consider and dispose of the representation in the meantime, if so advised. So advised. He may consider and dispose of the representation, and the pendency of the writ petition shall not be a bar for passing appropriate orders of the same representation. This matter again not.
Any date, your lord, please.
You tell us your dates.
My lord, immediately after vacation.
Immediate.
Why not?
Office has to go in vacation.
You are representing.
We are
You
taking
the
steps
council
tomorrow.
representing, therefore notice is a waive. 25th.
My lord, 25th.
25th April.
Can be 28th a lot. 28th.
Right.
28.
Well, the only thing, well, all this, everything was under closed down by the police, and the keys are with the police.
You will have to permit them to use the residence.
But the keys are with them, with the police.
They will have to permit you.
Well,
steps will be taken by the respondent authority to permit the petitioner and his aged mother to use the premises for residential purposes only as directed. Copy of this order. It's not necessary to be marked. You take certified copy.
the court provides for my friend, it would be better. It would be expeditious if honorable court permits a copy.
They're a fairly rich department. They can apply for certified copy. They'll get it in the afternoon.
Downloaded copy, I'll.
Yes.
Yes. Download it.
Obliged.
Obliged.
CGC. Yes. CGC is respondent 2.
Yes, my lord.
And respondent 1, Dusty has been taken,
My lord.
but none appears. So perhaps you may like to get an instruction as to whether you can represent respondent 1 or 2. At the also Dusty service by Dusty was effected by the petitioner and an affidavit to that effect by court by the on 4th of November 2024, wherein it seemed that the copy that service is complete on respondent number and proper endorsement.
Respondent number 1
here. But respondent 1. However, none appears for the respondent 2. So respondent 2, respondent 1 or 2?
Respondent number 1.
Union is respondent 1 or 2?
2.
However, considering that the Ministry of Home Affairs, Government of India, carried as respondent 2 at the request of the court, Mr. M.R. He has entered the theatre. Court has recorded the theatre. Mr. Rudikat be permitted to complete his instructions in the matter. After the first week of May.
Madam. All right.
Come back at 2 p.m.
2 p.m. ma'am.
We'll come back at 2 p.m. Mr. Sharma. We'll come back at 2 p.m. because it may not be complete in 2 minutes.
Wait, please, Your Lordship. Before Your Lordship, yes, ma'am.
The issue about it.
Issue, my lord, I am going to my lord. My lord, petitioner before Lordship, the MS Nodwar Koboto means Masmora Somawai Limited, my lord, 100% fishermen, my lord. They are, my lord, now a settlement holder, my lord. Please may kindly see page annexure 1, my lord. The Nodwar Koboto Miss Masmora Somawai Limited, my lord. My lord, for settlement order. And therefore, what happened, my lord, during the process of, my lord, running the Mohol in question, my lord, you know, one, my lord, there is a 2 fishery, my lord. One, my lord, Toru Dolpani and Big Dolpani. And my lord, Toru Dolpani, my lord, small Toru Dolpani, due to some development, my lord, for with the, my lord, government, my lord, forest department, my lord, develop the fishery, my lord. And my lord, what happened, my lord? When, my lord, please may kindly say page 25. Before doing the development of the fishery, my lord, the forest range officer, West Forest Range, Naksongkor, my lord, page 25, annex up 4, my lord. It is hereby informed by writing that the excavation work of Teliapal, Toru Dolpani Bill and Dangor Dolpani Bill falling under the West Biswanath Wild Division, Naksongkor, is going on for development, and it has been informed to the President Secretary Nodwa Koboto Fishermen Cooperative Society Limited, promising to keep open the steel tape and the mouth as per estimated of the bill. And after completion of the development, my lord, that barn embankment was not open, my lord. They promise us they are going to open the embankment. Because of that, due to band, my lord, the water is not coming and fishes are not going, my lord, for. So, my lord, please may kindly see page 27, my lord. Thereafter, my lord, some of the local person also that area, my lord, please may page 27, my lord. Minutes of the review meeting held on 5/9/2022 in connection with a dispute arising with regard to Dolpani Nolini Bill under Nodwa Revenue Circle. The members present have been enclosed annexure 1. A review meeting under the chairmanship of Sri Monindranath Deputy Commissioner was held in the conference hall of the Office of the Deputy Commissioner on 5/9/2022 in connection with the dispute arising with regard to Dolpani Nolini Bill under Nodwa Revenue Circle. As Dolpani Bill is the only source of water of the locality Toripal EDC, under so arrangement for supply irrigation water and for its development, but dispute arose between Lizzie and Bill and EDC, and subsequently, therefore, opinion was taken from the both parties in this regard. After taking opinion both the parties, it became clear that settlement of the bill was given to Nodwar Koboto Fishery Cooperative Society petitioner, my lord, for 7 years, that is so and so. Hence, it is informed in the meeting that no decision with regard to the matter, Dolpani Bill,
can be taken till expiry of the period of settlement, and leasee is paying revenue of the government, it will be able to get fees the bill till expiry of the period of settlement. Well, at that time they occupied the fishery, they did not even give the running the mahal money question, my lord. And thereby this dispute is going on. And thereafter, my lord, petitioner filed a petition on 22/9/2022, page 30, Annexure 6. The forest department promising us to open the embankment when for the purpose of development they doing that, my lord. I filed a petition, my lord, page 30, my lord, to the circle officer so link in connection with linking Soru Dolpani and Dangor Dolpani bill. We the undersigned have honor to state that as per order dated 5/9/2012 passed by the Deputy Commissioner, with this regard, Soru Dolpani and Dangor Dolpani bill, the embankment constructed by the Department of Forests on the two bills should be demolished. The earlier link should be continued. That is the link, my lord. All pieces are coming. Hence, the copy of the order of the Deputy Commissioner and so and so and so. Thereafter, my lord, circle officer, my lord, page 33, the pair for removal of the embankment constructed to Soru Dolpani to Dangor Dolpani, my lord. Please make kindly see. In connection above subject, in reference, I have the honor to state that President Secretary Nordwa Fisherman Covert Society Limited have submitted an application with a pair for removal of the embankment constructed in Soru Dolpani and Dangor Dolpani bills and reinstate the earlier situation. Hence, the matter is being forwarded to good self to take necessary action. And thereafter, my lord, additional Deputy Commissioner pass an order, page 35. Page 35. Page 35, Annexure 8. You got it, my lord. In connection with the above subject and reference, I am to inform you that since Nordwar Min Mahal has been given on lease to Nordwar Fishery Cooperative Society Limited 7 years, you are hereby requested to direct the Department of Forest and the leasee. My lord, we are the
Nordwar.
Yes, my lord. My lord. Leasee to demolish the embankment constructed in Soru Dolpani and Dangor Dolpani bill by the Department of Forest as per agreement entered into with the leasee and inform the undersigned, my lord. And pursuant to order, my lord, please make kindly see page 38. They, my lord, illegally occupied the fishery, and response number 8 to 10, my lord, I think my learned senior pen appeared on behalf of them, my lord. They illegally encroached, my lord, please make kindly see second last paragraph, page 38. That it is a painful to say that some person of the customary have been illegally encroached and possessing the government land and in front of customary bill, and they have dug large ponds and thus have been obstructing the moment of peace during the rainy season and also causing obstruction to the bill. If these illegal encroachments are not evicted on time, the area of the Min Mahal will be sneak and existence of the Min Mahal will be at jeopardy. We therefore earnestly pray your good self to be kind enough to so and so. And thereafter, my lord, again we file a representation annexure 10. Thereafter, the circle officer Nordwar, my lord, please page 44, my lord. Page 44, annexure 11. As in the order, my lord, as the inlet of Soru Dolpani bill, a part of Dolpani bill of Blaze Corpal number 1 Sotia Moza is lying close. It was decided in discussion held the office of the circle officer Nordwar Revenue Circle on Toronto in presence of regional forest officer West Forest Naksankar, officer in charge Sotia Police Station, President Secretary Nordwar Pavitra Fisherman Limited to Gao Pradhan. Sorry, case of so and so, my lord. Bill which stop flow, my lord, so and so of the bill which stops the flow of water and peace into the bill. Hence, the bond will be open on 3/5/2023 on the presence of above noted person. All persons present in the discussion held on so and so are requested to remain present at the said place on so and so on specified date. The circle officer issue the order, and thereafter, my lord, And all, my lord, thereafter, my lord, they are not doing, my lord, and immediately, my lord, thereafter I came before the honorable court,
On
and
3-5, nothing happened.
nothing happened. But no, my lord, they are going, they obstructed, my lord, my learned friend client. And thereafter came before the honorable court. There is the order, my lord. At that time, my lord, government honorable court given the assurance that we are going to, my lord, open that. Thereafter, my lord, file an affidavit, my lord, government, please may kindly see. Respondent number 2 file an affidavit. Para 5, my lord, page 114. May I read, my lord? That the beg to state that deponent was not aware about the subsequent development with initiative of the petitioner society for development of the fishery, namely so and so. Accordingly, according to work was undertaken by the Forest Department and Bishwanath Forest Division for construction of the embankment between Soru Dolpani and Big Dolpani Bill. But in the process of block, the entrance for flow of water into Soru Dolpani was closed, and for lack of water, fish breeding was adversely affected, resulting the loss of revenue from the lease out of the fishery. That the deponent beg to state that the petitioner society has further alleged that illegal enclosures constituted ponds over the fishery, reducing the area of the fishery. It is submitted that said embankment was constructed was the fishery at the initiate of the petitioner society through local forest department with the approval of local administration. It is submitted that follow-up action for removal of block of the entrance of Sorudolpani and encroachment of the part of the fishery are under domain of local administration, now under DC Bishwanath. That the deponent beg to state that the matter was not brought to the notice of the government earlier by LISI or by the local administration. Government respondent has come to know of the deponent the development through the instant writ petition only. The steps were taken for removal of the embankment on 5/6/2024 as per direction of the Honorable Guwahati High Court by the Bishwanath, DC Bishwanath, as reported by the DC Sunitpur by letter dated 26/6/2004. As per detailed report of CO, Circle Officer Nodwa Administration was ready to carry out the tasks with the men and materials with the adequate police force, but follow-up action could not be taken due to resistance by the local public, which includes women and minor children. Please may kindly see Annexure, my lord, 1, my lord. Regarding providing sufficient police security, this letter was issued by the Circle Officer Nodwa to Deputy Commissioner regarding providing sufficient police security for the removal of the embankment, separating Soru Dolpani, Bordalpani part, Fishery Mohol, so and so.
Why are you resisting?
My lord, before
Why
that,
the
my lord.
respondents are resisting?
My lord, I am, my lord, one, that's my lord. Yes, my lord. This is the, my lord, your lordship. Go to it, my lord. This is the government map, my lord, regarding our fishery. Here is a, my lord, 2 fishery, my lord. Your lordship, go to it, my lord.
Yeah. So this is some embankment.
My lord.
Huh?
Put us
But the state department has taken a decision to remove the embankment.
My lord, thereafter, my lord.
Cannot take, my lord, because it was decided that this is composite meeting held by all stakeholders.
No, whether they can decide or not decide, you can complain, but why should you resist?
No, I'm not, there is nothing to raise it.
On the other hand, my lord,
We cooperated with them construction.
only 5 minutes, my commissioner. At your lordship.
I'll ask you in detail.
My learned senior friend appeared on behalf of the one of the committee, NGO. And my lord, that NGO, they annexed their rules, my lord. The divisional forest officer is the member secretary of the committee. And my lord, divisional forest officer filed an affidavit. Please may kindly see para 5 page 51, my lord, your lordship, my lord. Page 51, my lord. Your lordship got it, my lord. 3 and 4, my lord. May I read, my lord? Page 51.
51.
My lord.
51 is the affidavit by R2.
Yes, my lord. Yes, my lord.
Respondent
Yes,
two.
respondent was 6, my lord.
No, respondent 2 in the R copy.
Page 2 kilometers. My lord, affidavit filed by the Forest Department, your lordship, on my lord.
Respondent number?
Respondent number 6, my lord.
6.
My lord.
6 to 8.
My lord, 6.
Is
The
filed by
Divisional Forest Officer, Biswanath Wildlife Division.
Huh? So 6 affidavit in opposition by respondent 6 to 8 is filed by one Dal Mohan Chetri.
Wrongly, my learned.
We are renumbered my letter on page 910. Solomon Secretary we are. It is a equitable committee formed under the
My lord, the Forest Department filed affidavit on 27th day of March 2025, my lord. Filed by the Divisional Forest Officer, Biswanath Wildlife Division. My lord, lordship got it, my lord. Paragraph 4, my lord. The deponent would like to state that though the Forest Range Officer, West Forest Range, Naksankor, Biswanath Wildlife Division by the certificate dated so and so, that annexer 4 of my petition, this is they give the undertake, my lord, that certificate, my lord. They admitted that they given. Certified that seal trap and mouth front entrance of the bill shall remain open as per the estimate of the bill, but for completion of the work of the execution of the bill, the inlet of the bill had to be closed to prevent water from entering the bill. However, after the completion of the work, due to obstruction by the local public, the mouth of the bill could not be opened. The annexer B, my lord. Further, as per minute so, my lord, please may kindly see.
You are concerned with the fishery. You are settled with the
Where
fishery.
where the settlement holder?
Who has given you the settlement?
My Deputy Commissioner Punitpur, my lord.
Who
My lord,
is for the deputy commissioner?
they file affidavit,
So
my lord.
you have been receiving revenue from the petitioner
My lord.
for the fishery. So if he is not able to operate, you either refund or enhance his, bring down the cost. If you can't give him the fishery to be operated properly, you compensate him.
Main question is, my lord, we are the 100% fisherman depending on fishery, my lord.
Right, but if you're not
But
able to operate,
no, my lord, this embarkment was done for the purpose of development, my lord. And thereafter, my lord, this is the government fishery, and thereafter this ban was made only for the development of the fishery Sorud Dolpani. Now that small area with you have open, all waters and feeding fish are coming, that will be the, my lord, people lord will go to it, my lord. The map, my lord. So I am praying before lordship to my lord, open the bill, my lord, open the, my lord, filtered, my lord, area, my lord.
the state has filed an application that because of local obstruction, they were unable to open, unable to.
Oh, my lord, your lordship direct that, my lord. They can obey, my lord, because this is a government property. How can they occupy this property?
Who is for the forest?
Forest file affidavit, my lord.
Who is for the forest?
My lord, they have to do it, my lord. If this filter was not open, my lord, the fish and water is not coming, my lord.
That is what we are asking them, that you have been settled with a fishery.
My lord.
You are paying some revenue to the government.
That is correct, but due to,
but if they are unable to ensure the proper means to operate the fishery, they will compensate you.
Because of the obstruction by the
We don't know because of what it is your fishery. You decide which part of the fishery is to be operated, which is to be obstructed. You decide. If you are unable to decide,
we have already decided.
you have decided, but you are on your. There is an. Are you saying that the state is helpless to take action because of obstruction of local people?
If forest department is going to open it, the government is going to open it. This is
Where
the
is the
government
forest
fishery,
department?
my lord.
Where is the forest department? Forest department. Yes, Mr. Sharma, what do you have to say? Why are you obstructing?
You are not obstructing, my lord. It is as per the project report, my lord, that you will also kindly find in IA number 2436 is part of the record.
IA.
That was disposed of, my
IA for what?
for implement, my lord. That implement
Now you have
to implement
please
is there.
don't disturb me.
No, no, still not completed. Two
Let
IO
him
was
complete,
there.
man. Then I'll argue.
First IO was dismissed.
Let him
Thereafter
complete,
they
I'll
again
argue.
What is the
filed.
order that you want today? What order do you want?
I want, my lord, we want only because of that this embarkation may be open because by your lordship is directed to the deputy commissioner as well as forest department to do the needful, my lord, because of this fishery only my lord, earning of our society, my lord, whole 100% fishermen,
Is
my
what
lord.
we are saying. If you are unable to, if you say that because of this band, your fishery, you are unable to operate, we'll direct them to calculate the compensation and give it to you.
No, my lord. If our problem is that my lord, whole 100% fishermen was depending on that area, and my lord, they are in illegally occupied this my lord fishery, my lord. What is his right, my lord? That is my
Then
lord.
you file a civil suit. You file a civil suit.
Well, it is the government authority has the power, my lord. Government
This
authority.
is a matter of measurement of the proper land
No,
embankment.
my lord, I have given the map, my lord. You will also go through
You
it, my
have
lord.
given the map. It's a trace map.
No, I will file an additional affidavit that map that if this record is required. This is a certified copy of the government, my lord.
So are we to decide how much is the length of the fishery and how much is the length
Yes,
of the
everything is there in the map.
Why should we decide that? Why should we decide? Why should we get into this dispute of deciding what is the length and breadth of the fishery? There is a civil court. Go and file it before that. Your grievance is that you have been settled with a fishery. You are not allowed to operate it
No,
to the proper extent.
that operation is not a concern. We concern about the opening the embankment.
Why?
Why? Because of that, all water and fishes are coming from the big Cholpani bill.
How are you affected?
Affected fishes are not coming.
That is what we are saying, that you are not allowed to operate it properly.
That is why, my lord, we file a representation before the competent authority doing that in
They are not doing
properly with all, my lord, force, my lord. Now, my lord, they are preventing, my lord, so thereby.
They means who?
They mean, my lord, the committee, my lord.
The committee.
Committee.
So you go
a committee, my lord, they are coming, even forest department.
You go
DFO
and
is
file a
the
suit against them. Get them evicted if you want. What? Who are these people? Who has certified that this committee is obstructing? Who has constructed the bund in state?
The forest department, my lord, they have
Where
given.
is the forest department council?
I said, coming. Forest department before they were taking development before construction, they say that don't worry, we are going to just block the ban and after completion of the fishery,
The
we'll open.
government has filed an affidavit expressing helplessness. How is that? How is that possible? You have settled it. You have settled it. Why did you settle it in that place? Your duty is to ensure that the work gets completed. Your duty is not to complete formalities only.
Because of that, my lord, forest department and DC, some communication gave thereby that doing. Now, my lord, your lordship sent
All right, you get up-to-date status report on this. Art Clerk Council for the party.
Hello, one more thing, my lord. PNP is the financing authority through the government of India. Out of 1 crore, 9 lakhs sanction for this.
We are not getting into anything more. First thing we want to find out who's responsible for creating the bun, and in view of the averments made in the affidavit, what steps the government will take to remove that bun. There is a clear averment that it needs to be removed.
Yes.
They are unable to do it because of local obstruction.
No,
So
it
let
is
them
not
get
local.
that instruction.
What is affidavit is in paragraph 3 has already clearly said, because for climate resilient, may I take a lawsuit to
No, Mr. Council, if you are aggrieved that somebody is trying to remove a ban, you file your petition independently. This is the petition filed by him for removal of the ban. Whether the bund is necessary, funded by wildlife or whatever is on a different issue. Let the forest department is not here.
Let them
So
get
let the government clarify the position,
Yes.
find out, and then whatever orders are necessary, we'll pass it. Heard learned counsel for the parties, Mr. N. Bora for petitioner, Mr. M.S. U. Sharma, U. Das for government, Mr. R.P. Sharma, senior counsel, assisted by Mr. M.R. Odhikari, for the respondent number
8, 9, 10.
8, 9, and 10. None represents the forest department. The dispute between the petitioner and the respondent is the erection of a PUN, PUNTA, with books. In an in a bill, PWEL bill, adjacent to the fishery, which has been settled with the petitioner. According to the petitioner, because of the erection of the pond, it has obstructed the free flow of water and fish into the fishery, which has been allotted to the petitioner by the respondent authority. In view of the obstruction caused, representations were filed before the concerned authorities, and the revenue authorities, including the deputy commissioner, had decided to remove the bund. However, on because of obstruction by local people, this bund could not be removed. Stop. The petitioner therefore seeks appropriate orders, seeking a direction to the respondent authorities to take adequate steps for removal of the bund in order that there is no obstruction for free flow of fish and water into the so-and-so bill or the fishery, which has been settled with the writ petition. So, although the government has filed an affidavit where there is a clear averment that decision was taken to remove the bund, but because of obstruction of the local public, the same could not be done. Government counsel appearing before the court is unable to apprise the court as to the steps that, whether any steps are taken at present to remove the bund in terms of the decision taken by the authorities. So, under such circumstances, the court directs the government advocate to complete her instruction and apprise the court as to the steps required to be taken and of legal taken by the respondent, by the deputy commissioner.
And also the forest, both. Forest is the constructing authority.
And with regard to the removal of the obstruction / the bund. So, although forest department is the raid as the party, however, not represent the forest and the matter is brought up. In view of the submissions made by the petitioner that the bund, petitioner and the senior counsel appearing for respondent 8, 9, 10, that the bund has been erected by the forest department. The learned government advocate will also obtain instruction that effect and place it before the court by the next 8 days. Based on 2nd of May.
Now, can it be under
28th of April, my lord.
No, my lord. I'll be a bit,
29.
I'll be a bit busy, my lord. Can it be on 3rd or 4th of May, my lord?
25th of April.
No, my lord,
Hold on, what, my lord?
Not tomorrow, day after.
Last 14 days.
Can it be on 3rd May, my lord?
3rd May?
3rd May.
3rd May is a Saturday.
Then 5th May.
5th May.
Yes.
All right, list on 5th of May.
How like that?
5th of May?
March.
Item 21.
Lordship, my senior legs in another court, Lordship. My senior legs in another court.
It will come after vacation. He has any instruction?
Yes, instruction is there, my lord. There is a theft of electricity, my lord. We have filed an FIR also, my lord. But there is alternate remedy if they want to challenge the assessment bill, my lord, under 126 of the electricity.
Counsel for the petitioner prays for accommodation for some time. However, considering that tomorrow is the last working day, matter be listed again on 21st, immediately on the reopening date, that is 21st of April. Mr.
Pidas.
Pidas appears for the APTC. Yeah, 21st.
Here we have filed an IA for withdrawal of petition.
Withdrawal of which petition?
Arbitration 32.
Third counsel for the part. This is an IA 1212. The counsel for the petitioner has filed his IA seeking praying for grant of liberty to withdraw the arbitration petition number 32 of 2021 filed with the petitioner under section 11.6. There are prayer not being objected by the counsel for the. Anybody appeared in the arbitration petition earlier?
Yes, but we have some copy. They were here.
Although it is submitted, that advance copies have been served on the counsel for the respondent. None appears for the respondent. And in view of the prayers made, I said aloud, the petition, the arbitration petition to closed and dismissed.
Obliged.
I
Yes. Item 17.
My lord, last occasion, I was directed to produce my lord the record regarding service of my lord Choco's notice. What happened, my lord, in this case, the entire record, because police case was also registered on filing of FIR, and all records were seized by the police, my lord, for investigation. So, my lord, now since the records are with police, we could not find my lord regarding his endorsement of receipt of the so-called notice, my lord. We haven't tried to charge the my lord process servers register. That also is not, my lord, we could not find out. And I have received the letter as per after this honorable court's order direction to produce the same. I have received on 8 for a letter that whereby, my lord, it is informed that, my lord, the charge for official record is still on and under process.
These pleadings were complete.
Meetings, my lord, yes, my lord, we have filed the affidavit.
All right. Matter be listed for admission hearing.
My lord,
on.
my lord, I have simple submission in this regard. Just I would like to state the facts in this case before this honorable court.
We want to, if we are not hearing, disposing of the matter today.
My lord, here is one last, today is the 7th occasion. Same order was passed by calling. One is a
We
process
will hear
server.
the matter after reopening. Is
My
there
lord,
any urgency that it
yes,
must be
yes,
heard?
my lord, urgency
There is an interim order.
No, my lord, though there is an interim order, but subsequent development is there. Kindly.
Let him place it by filing an IM, my lord. Last occasion also.
There
he
is
has stated
interim order is there not to take any coercive action, and accordingly, I have make a representation before the authority not to take any action during the pendency of this case, but not considered my representation, and this order have been passed.
You bring it on record.
My lord,
File an
my lord,
whatever.
maybe this order may be stayed till next.
No, on what basis?
My lord, otherwise,
Not-
otherwise my case will become
When did you
infectious.
receive it?
My lord, otherwise my case
When
will
did you receive this order?
during the pendency after passing the interim order.
Which date? Which date?
That was that was, my lord, 26 March.
What date is today? What have you been doing for so long?
My lord, yeah, during the there is a interim order not to take any coercive action, and during the continuance of that interim order, this action has been taken by the authority. My lord.
Petitioner, it is submitted that
Till
notwithstanding
next
the
returnable,
interim order passed
this order
earlier
may be stayed, my lord.
by this court, council has placed before the court an order dated 26th of March 2025. This is about what? Holding a meeting.
Holding a special
Special
meeting.
the district deputy registrar of the cooperative societies Borpeta has issued the direction to the chairman of In Titapani Samavai Committee Limited to proceed for holding a special board of directors meeting as the concerned authority is of the view that there can be no impediment in holding the same, notwithstanding the order dated 27/1/2025 passed in the WP7. The counsel for the petitioner is permitted to bring the copy of this order by uh, is at liberty to challenge this order by taking appropriate steps, if so advised.
What I'm trying to submit till next returnable from this order, if any subsequent development.
What have you been doing from 26th of March? Why did you not bring it in record when you were of the view that the interim order was violated?
Then, my lord, kindly go through the order dated 27/1/2025.
27/1.
2025.
Yes.
Then 17/2/2025.
Wait. Let us first take one by one. 27/1.
25, my lord.
25. Yes.
By this order, same inspection was called for. And after that, 27/1/25, 17/2/25, 5/3, 25, 13/3, 25, 9/3, 25. This so many occasion was given to the respondent to produce that process server report, and accordingly matter was continuously listed in the admission hearing column for final disposal. On last two occasions, coordinate bench of this honorable court, not in the recorded in order, but verbally told that in the open court that this was the last chance for them to produce that process server report. So, my lord, I am humbly submitting before this honorable court. If this order is not stayed by this honorable today, then my
There
case
is an
will
order saying that no coercive steps be taken. That's all.
But this action has been taken.
This action, you are not challenging it. What can we do?
My
Should
lord,
we invite you to challenge it?
No, I have submitted representation before the authority.
You keep on submitting representation.
My lord.
List again on 23rd
My lord.
April. You do whatever you feel like. You are a counsel.
My lord,
You advise your client what is to be done. There is an order from 26th of March. You are holding on to the order.
My lord, thereafter, short date was given in many occasions to the final disposal of this case. And I am waiting for the final disposal. And again, seeking time on the same ground, they will produce for some.
Please take it on 23rd.
23rd.
Mr. So-and-so, yes.
Well, I want to file the IA in this regard.
You file. We are not stopping you from filing. MSU
Das
maybe continue.
Government, Mr. Rajpura for the Cooperation Department. The interim order, needless to say, interim order passed early, 23rd. Yes.
But in this case, DD Kumar is entering by filing an caveat method.
Huh?
What caveat has been filed
Caveat
by we have not the copy. But he is not made party here.
Then you have to give them copy. Heard caveat. Caveat number 12. Caveat discharge. You are appearing for the caveator.
I am appearing for the caveator.
You are appearing for. What is your name?
H. Agarwal. H. Agarwal.
H. Agarwal. Yes. You have to make him a part.
Well, he is not the person affected as such, my lord, and I have not been
filed
made
a
party.
caveat.
My lord, it is just because they have objected, so my lord, we have given him the copy. Now, my lord, my whole grievance is against the technical evaluation committee who has rejected my bids.
He is the shortlisted one. Aviator is the shortlisted.
He is appears to be my lord
I'm the
shortlisted.
technically responsible.
Tomorrow is the date of my lord opening of the financial bid.
Oh. When were you rejected?
My lord, it was rejected on my lord 2/4/25. That was uploaded on 4/4/25. I have submitted a representation on 5/4/2025 in consonance with my lord the clause 23. That has not been my lord considered till date. On the other hand, my lord 11 has been fixed for my lord opening of the financial bid. My lord, at this stage, my lord, my prayer would be let the authority open my financial bid as well, my lord. And final, my lord, the result may not be declared. Lordship will kindly see, my lord. The clause 23 specifically provides the duty, my lord, for them.
23.
Lordship.
Which page?
It is page 67.
67.
Sir. Mary,
Yes.
few of the clauses, my lord. 23.1. Bid opening shall be carried out in two stages. Firstly, part one, technical bid of all the bidders. Receipts shall be opened on the date and time mentioned in the notice inviting tender. Part two, financial bid of those bidders whose technical bid has been determined to be substantially responsive shall be opened on a subsequent date through online process of e-tendering, which will be notified to such bidders. Then Lordship may come to page clause 23.4. The bids accompanied with valid bid security bid documents fee will be taken up for evaluation with respect to the qualification information.
What is it that you want to point out from this clause?
Lordship, my lord.
What are you pointing out?
My lord, this clause also, my lord, in this clause itself, my lord, as soon as possible, the employer will finalize the list of responsive bidder whose technical bid are eligible for consideration. However, to assist in the examination, the evaluation of the technical bid, the employer may at his discretion ask any bidder for clarification of his bid. However, no additional document in support of clarification will be entertained. My lord, this exercise they could have done, my lord, because
That
I am
is
not relying
discretion.
on any documents. All the
That is
documents.
discretion.
That is discretion. Then your lordship will come to my lord 23.5. The employer shall inform the bidders about the result of technical evaluation by uploading on the web portal.
What is the contract about?
Or it is, my lord, maintenance contract of the road. 23.5 speaks that, my lord, the technical bid will be uploaded for a period of 7 days, and he will hear the objection or the, my lord, anything, and thereafter only the technical bid will be finalized. Now here on 4th, the, my lord, technical bid was uploaded. I have submitted my representation on 5/4 objecting to the, my lord, the clauses where they have found me non-responsive. With all the documents, what is there in the record itself, I am not relying on any. Instead of doing that, man, within a period of 7 days, they have fixed my 11 is the date.
So if you start from 4th, 7 days expires today.
If my lord,
if you count from
technically
4th,
taken both, it included both the dates in that case, otherwise, my lord, with them. But in the meantime, my lord, they have to, my lord, consider the objection, and then only they have to make a final, my lord, technical evaluation.
you have filed your objection.
Yes, my lord, on 5th. My lord, I am not on the, my lord, halting of the process. My lord, let the, my lord, financial bid that is open, that maybe my bid will also be considered, subject to the decision what the lordship will take up at a later stage.
Lord, it was uploaded on 4/4/2024 at 4. What I am trying to show, Lord, the two grounds has been thrown by the authority for rejecting his technical bid. Lord, it comes to paragraph 15. I am at the second reason.
Paragraph 15, page number.
Page 15, paragraph 10. Lord, Dr. Prima facie it shows that the tender has been rightly rejected. 10. That the petitioner said that second ground for declaring the bid of the petitioners as technically non-responsive is that petitioners have not shown committed work in the existing commitment as per clause number 4.2 of the RFP, and even though the petitioner have been declared as L1 for the job number so and so on 24/12/2024. Under the PWD NH work Assam, same is not shown in existing commitment. So this was the work lordship wherein he was declared as winner L1. Although LOA was not issued on that particular day. This is the ground of the petitioner that it was not shown because LOA was not issued. Now, if Lordship comes to clause 4.2,
All right, you get your instructions. We'll keep it on 22nd or 3rd or whatever date you want. 21st after reopening.
I have no objection.
You proceed for evaluation, but don't give the work order.
The only issue is that this is a road from Lakhimpur to Dibrugarh. It's a very bad condition.
Because what is your grievance that your
Madam, the ground he has cited, Lordship may kindly see page 125.
125.
This is part of the bid documents I have submitted. But they have said in respect of one walk where I have been judged as L1, but LOA has not been incorporated there in the Annexure 6. But here I have mentioned two jobs, not only one, two, one in Assam, one in Mizoram. And the reason I have furnished why it has not been mentioned in the Annexure 6.
You examine, he's got a representation before you.
Yeah.
You examine it and give us the information tomorrow. We'll take it up tomorrow. You examine and see what can be done. Or we'll keep it on 21st and you tell us on 21st what is the status.
But Lordship will allow us to proceed with the financial bid.
You financial bid you open, but don't give the LOI until 21st.
Till 21st. Till the next day.
Till 21st.
Yeah.
You examine his case, proceed for the financial bid.
In the meantime, Lordship, the representation that he has filed, Lordship.
You examine it.
If in the meantime has not been examined, Lordship, that
if not examined, then 21st you tell us what is the status. Further orders if required will pass.
Well, my financial bid also can be opened.
Not necessary. Not necessary. If at the relevant point in time, if after examination, if we find that yes, there is some problem, we may direct them to examine your financial bid. But not until then. Let them first respond to your representation.
Similar matter, the same ground, the respondent has, the other respondent has approached against us, and we have been, the prayer of the respondent has been rejected, and
you place it on reopening date. Yes. Heard Mr. P.J. Soikia, London Senior Counsel, assisted by Mr. K.J. Soikia. Also heard Mr. P. Nayak, London Additional AP, hearing from the respondent, Mr. H. Agarwal for the caveator.
H. Agarwal
for the caveator. Stop. You are one of the.
I'm the responsive, technically responsive. Out of the two.
Okay, you are the only one.
No, out of the two.
There's another one.
Another one.
The petitioner is agreed by the rejection of his technical bid in the NIT.
Dated 18/1/25, page 34.
Dated 18/1/25, issued by the respondent number 2 for performance-based maintenance contracts to NH-15 from so-and-so to so-and-so, page number 2. The grievance of the petitioner is that in terms of, where are the clauses?
23.
In terms of the
Here rejection clauses 4.2.
Where page number. in terms of the
105.
tender condition, the after technical evaluation, the same is to be uploaded in the web portal, giving 7 days time for objection. So it is the submission of the counsel to the petitioner that his technical bid was rejected on 2/4/2025, but uploaded on 4/4/2025. Stop. He had represented before the authority by his representation dated
5424. Page 121.
5/4/2025, which the authorities have not considered as on date. So it is submitted that in terms of clause 23.4, there is a provision to assist the evaluation of technical bids at the discretion of the employer by any bidder for clarification of its bid. Stop. Then its senior counsel submits that that discretion was not exercised by the authority, although the petitioner was ready to offer his clarification in support of his bid. And further, the representation filed was not considered within the period of 7 days' time, and without considering the state representation, and without following the procedure prescribed at clause 23.5, the petitioner, the respondents are proceeding to open the technical bid tomorrow, which is 11/4/2024. So, yeah. Let the respondent, let the PWD authority complete their counsel for PWD authority complete his instructions in the matter, and matter be listed immediately after the opening on 21st of April, by which date the instructions be completed and counsel may apprise the court. Stop. The department is permitted to proceed with the opening of the potential bid. However, till the next date fixed, no work order be issued to the shortlisted candidate. List accordingly on. Yes, Mr. Kaur, you're not arrayed as a party.
I'm a caveator, but I was a necessary party because we are the successful bidders.
No, that is what we found out. There are two bidders.
Yes, well, they ought to have been made a party.
They ought to have it, but not made.
I'll make them party.
Not made. If he wants to make it,
He's kind enough to make us party.
he will decide on that.
Yes. Well, others will file an
Otherwise,
application.
we are not directing.
Yes,
you
it's
to
fair
be
enough, my lord.
Implemented as a party as yet, in view of the fact that there is another party.
Yes.
As on date, we don't know who's going to be the shortlisted bidder. So,
if
first we may see.
On the next step, never become.
Because they have
Once the
determined to reject my application.
No,
That
once
was
the-
disclosures
no,
from
no,
your mind.
no.
Decision has been taken.
No, once the financial bid is open, Lord, he will self-realize which I have.
Because that means they know
No,
the
but then
financial
you
bid.
must know his financial
Yes.
bid.
No, we don't know. We don't
Then
know.
how do you know?
He knows.
My lord, earlier Mr. Saikya was unlucky once. He approached this honorable
That's what
court,
I was informed.